डीन सर की अभी जो स्पीच हो रही थी उनका विजुअल था लेकिन उनका माइक ऑफ था।
हाँ, तो क्या फिर हम
हाँ, अब आपका साउंड आ रहा है सर। पांडे सर का साउंड अब आया।
Voice how to play. So now audible? Oh. Now you're audible, sir.
Yours one is audible, but the another one जो पूरे स्टेज का विजुअल ले रहा है, that mic is off. So whatever mic you are going to use, keep it on.
Now you're audible, sir. You can go ahead, sir. Bisaria, sir.
Just wait for a while. I have to communicate the faculties over here to connect. They all are waiting till now. I'll just have to ask them to connect, switch on the mic.
Okay.
on their address?
Is it possible that you can give your speech first, then the Bisaria sir will join? We'll continue.
May I now request Ms. Nidhi Kastawar, Assistant Professor, School of Law, Raisoni University, to kindly introduce our chief guest, Honorable Shri Bhushan Prakash Sagar sir, Registrar, High Court of Bombay, Nagpur bench.
It is now my privilege to introduce our distinguished chief guest for the day. Honorable Shri Bhushan Kumar Sagar has an illustrious academic and judicial career marked by excellence and commitment. A first-class graduate in science with distinction in mathematics. He went on to secure the first merit in LLB in 1997 and was awarded 2 gold medals by Nagpur University. He completed his LLM in business law with first class in 1999. His dedication to legal education was reflected in his tenure as honorary lecturer at Law College, Akola. Excelling in the Maharashtra Judicial Service Examination, he stood among the top 10 candidates and was later elevated as session judge in 2016-17. Since June 2005, he has been serving as Registrar Administration at the High Court of Bombay, Nagpur bench, where his administrative acumen and sense of justice continue to inspire the legal community. Sir, we are deeply honored to have you with us today. May I now request you to deliver the inaugural address.
मराठीचा प्रॉब्लेम कोणाकोणाला? So you are comfortable with English and Hindi. All students can relax. They can sit as they want. They can relax as they want. If they want to listen, they should listen. If they don't want to listen, they should not listen. All freedom to you. Constitution has granted me the liberty, the fundamental right of expression, and I grant you the liberty not to listen me. Thank you. The dignitaries on the dais, Dr. Nityanand, Parat Khan Madam, Dr. Raman, the dignitaries who are online, and dear students who are present here. The topic which is allotted for this seminar is criminal laws and justice reforms. यहाँ जो बच्चे लोग आए हैं, मैं बच्चे लोग भी कहूँगा, सबसे पहले इनको पूछना चाहूँगा कि इसमें से कितने लोगों ने LLB के लिए जो एडमिशन ली है, ये एडमिशन खुद की चॉइस से ली है, प्लीज. See, this will be an interactive session. I don't wish to convey traffic. I am speaking, you are getting bored, you don't get connected to me, I am not getting connected to you. So I am putting some queries, questions to get connected to you. So let me know how many of you have taken admission in LLB out of his own will. ये जो सारे जितने बच्चों ने हाथ ऊपर किए इनको मैं करेजियस कहूंगा, डेयर्ड कहूंगा. द रीजन इज, आज के दौर में ऐसा कहा जाता है कि लॉ ऐसा फील्ड है जिसे बैंक लोन देता नहीं है, लैंडलॉर्ड घर देता नहीं है, और एक बाप अपनी बेटी देता नहीं है. और ऐसे बैकग्राउंड में ये बच्चे लॉ फील्ड करियर चूज कर रहे हैं. तो ये जिन्होंने हाथ ऊपर उठाया इनके लिए थोड़ी तालियां बजाना चाहिए. जो यहाँ उपस्थित है, थोड़ा अनकंफर्टेबल हूं मैं हिंदी, बिकॉज माय मदर टंग इज मराठी. सो लैंग्वेज बैरियर रह सकता है, बट लैंग्वेज बैरियर नहीं रहेगा. आई वांट टू कन्वे, कम्युनिकेट व्हाट आई वांट टू कन्वे. जितने स्टूडेंट्स यहाँ आज उपस्थित है, इसमें से कितने लोग आउट ऑफ ओन आए हैं और कितने स्टूडेंट को कंपल्शन किया है? जिन्हें कंपल्शन किया है उन्होंने अगर हाथ ऊपर किए तो आई विल बी वेरी हैप्पी. एक भी डेट नहीं है जो कबूल करे कि कंपल्शन किया है. एक है, दो है, 3, 4, 5, ये सारे बच्चों के लिए भी तालियां बजाएंगे. See, why I am saying this? I graduated from Amravati University in law. I took admission in LLB first year in 1994. I completed my graduation in law in 1997. I stood topper throughout 3 years in Amravati University, bagging 2 gold medals. There was a complaint to my father. My father was practicing advocate at Akola. He is still practicing advocate in Akola. The college administration moved a complaint that, sir, your child ward is not attending the classes. My father asked me, काय रे, रोज कॉलेजला जातोस का? हिंदी, क्या रे रोज स्कूल जाता है क्या, कॉलेज जाता है क्या? हाँ जाता हूँ. डेली जाता है? हाँ रोज तो जाता हूँ. क्लासेस अटेंड करता है क्या? वो नहीं करता हूँ. कॉलेज क्या करता है? मैं दोस्तों के साथ गप्पे मारता हूँ. कंप्लेंट आई है कि तू कॉलेज अटेंड नहीं करता है, क्लासेस अटेंड नहीं करता है. दे आर राइट. अगर किताब में से पढ़ने, अगर सिर्फ किताब में जो लिखा है वही अगर मुझे पढ़ के बताते होंगे लेक्चरर, तो वो तो मैं घर पे ही पढ़ूंगा ना. उसके लिए मुझे कॉलेज जाने की, वो सर का लेक्चर अटेंड करने की क्या जरूरत है? यू आर मोर फॉर्चुनेट, आपके पास किताबें हैं, आपके पास ऑनलाइन है, आपके पास यूट्यूब है, आपके पास क्या क्या नहीं है वो सारा है. तो मैं तो ये कहूंगा कि ये कॉलेजेस की कोई जरूरत ही नहीं है आज. तो आई विल अपील टू द कॉलेज एडमिनिस्ट्रेशन कि इनको बच्चों को कॉलेज आने के लिए कंपल्सन करना या नहीं करना, इन्होंने एक थॉट देना चाहिए. अभी ये सेमिनार क्यों अरेंज करना है, ये सेमिनार क्यों अटेंड करना है? ये सेमिनार अरेंज करने का एक पर्पज होता है, एक्सचेंज ऑफ थॉट्स. See, I have completed 24 years as a judge. Before entering as a judge, I practiced 4 years as an advocate. So in this legal field, I have 28 years of experience. For last 6 months, I am on administration side. जुडिशरी को ऑलमोस्ट 28-29 ईयर्स से देख रहा हूँ. अपना टॉपिक जो है क्रिमिनल लॉ एंड जस्टिस रिफॉर्म्स. आप कल ये फील्ड में आने वाले हैं. रिफॉर्म इज अ कंटिन्यूअस प्रोसेस जो एंशियंट टाइम से कंटिन्यूअस चल रही है, आज भी चल रही है, कल भी चलते रहेंगी. तो सेमिनार क्यों लेना है? तो सेमिनार इसलिए लेना है कि यहाँ एक्सचेंज ऑफ थॉट्स. तो एक्सचेंज ऑफ थॉट्स सिर्फ बुकिश थॉट्स नहीं होते. ये 24 ईयर्स 28 ईयर्स में जो हमने एक्सपीरियंस लिया है, ये एक्सपीरियंस आपको कौन सी किताब में मिलने वाला है? कोई किताब में ये एक्सपीरियंस नहीं मिलेगा. तो जो एक्सपीरियंस लिया हूँ, ये एक्सपीरियंस का क्रक्स अगर मैं आपको शेयर करता हूँ, तो ये आपको ना कोई ऑनलाइन प्लेटफॉर्म पे मिलेगा, ना कोई किताब में मिलेगा. और फॉर दैट पर्पजेस सच सेमिनार्स आर टू बी ऑर्गेनाइज्ड, and for these purposes such seminars are to be attended. Okay. थोड़ी देर पहले मैं कहा, सब बच्चों के लिए तालियां बजाने के लिए कहा था जिन्होंने ये फील्ड चूज किया. एक पर्सनल एक्सपीरियंस शेयर करता हूँ. In 1997 I completed my LLB. As father was practicing advocate, I started practice in the ऑफिस ऑफ माय फादर हिमसेल्फ. पढ़ाई भी चल रही थी, LLM चल रहा था, प्रैक्टिस भी चल रही थी. एक छुट्टी के दिन ऑफिस में बैठा था, दोपहर का टाइम था. एक बुजुर्ग आए. मैं ऑफिस में अकेला था, पिताजी नीचे खाना खा रहे थे. तो पिताजी को मिलके ऊपर आया. पिताजी ने बोले वेट कीजिए, 10-15 मिनट में आता हूँ. ये साहब 10-15 मिनट हमसे बातचीत करने लगे. काय रे काय करतोस? क्या रे क्या करता है? कुछ नहीं, अभी LLB हुआ हूँ, 1-1.5 साल हो गया, प्रैक्टिस कर रहा हूँ. दूसरा सवाल, कुछ काम भी आता है आपके पास? नहीं आता है. कुछ कमाई धमाई होती है? नहीं होती है. तो फिर खर्चा कैसा करेगा रे? आगे जिंदगी कैसे काटेगा? बाप कमा रहा है, मेरा भी गुजारा चल जाएगा बाप की कमाई पे. 2-4-5 मिनट उन्होंने बातचीत किए. फिर बोले बाप अपने पिताजी को बता देना कि मैं चला गया. ओके. मुझे वो किस चीज के लिए आए थे, कौन सा मैटर था, कोई पता नहीं था. वो चले गए. बाद में पिताजी है 15 मिनट बाद ऊपर. अरे वो आए थे, किधर गए? वो तो चले गए. क्यों? उनका क्या काम था, क्या क्लाइंट है? अरे वो क्लाइंट नहीं थे, बोले वो तेरे लिए रिश्ता लेके आए थे, बोले लड़की का. फिर मुझे पता चला कि ये 5 मिनट में जो मेरे से बात हुई, ही टुक द डिसीजन, नो ये अच्छा कैंडिडेट नहीं है. सो दिस इज. पर फिर भी ये फील्ड में आना चाहिए या नहीं आना चाहिए? सो आई विल रिकमेंड दैट यस, दिस इज द वेरी गुड फील्ड and one must come here. I say one must come. My son graduated, my son is going to get graduated in LLB 5-year course. He is in National Law University Nagpur 4th year. Out of choice, after deliberation with me, he took admission. My daughter, she is in 11th. She scored 98 marks in biology in 10th. Again, we had a talks. She asked me what to do. I gave her liberty. Yes, it is your choice. You should pursue the career of your choice. She said, I want to go to commerce. I said, okay, fine. हर लोगों ने मेडिकली जाना है या इंजीनियरिंग जाना है, ऐसा कोई जरूरी नहीं है. So she took admission in 11th commerce. यहीं पे रविनगर में जो कॉलेज है, क्या नाम है कॉलेज का? GS Commerce College, right. Then she asked me क्लैट का ट्राई करती हूँ. मतलब ओके, क्लैट का ट्राई करो. So I am trying to show that this field is very bright field. Unfortunately, what has happened, more number of colleges are opened, more number of students who are not serious in this field, they have taken admission. And because of that, the number of advocates we see increased. But in this, as we say, blessings in disguise. Those who want to pursue this as a bright career, they are having very bright chances because competition बहुत कम है ना भाई. आपके पास competition में कौन है? तो जो bright है वो तो bright रहेगा ही, वो आगे जाएगा ही. So now let us turn to our topic, criminal law and justice reforms. Social media कितने लोग देखते हैं? सोशल मीडिया पे क्रिमिनल जस्टिस सिस्टम के बारे में क्या कहा जाता है? Yes, anyone? Whether our criminal justice system, yes, mic देन दे तिकडे. हमारा टाइम लिमिट कितना है? हाँ? लोग बोर भी नहीं होना चाहिए.
They say that they are biased and inclined towards women.
Biased and
Inclined to women.
inclined to women. Okay. Any other view? Yes, yes, please feel free. I don't want to know your name, your class. I am not going to trace anyone. See, एक कहानी है. एक जंगल में एक, yes, you want to speak something? एक जंगल में गैया दौड़ते रहती है. वो दौड़ते रहती है तो उसे एक हाथी मिलता है. वो हाथी मिलता है, ए गैया गैया तू क्यों दौड़ रही है? वो गैया बोलती है, अरे यार यहाँ की पुलिस हाथी को पकड़ने चली है. बोले लेकिन वो हाथी को पकड़ने चली है, तू तो गैया है, तू क्यों दौड़ रही है? बोले अरे यहाँ की पुलिस गैया को भी हाथी बता देंगे. बोले गैया को बताएंगे, हाथी तो कोर्ट है ना देखने के लिए. अरे कोर्ट को साबित करने के लिए 20 साल जेल में रहना पड़ेगा. बोले तो ये एक कहानी है. कुछ हमारे कोर्ट में एक्सपीरियंसेस आते हैं. एक लाइव यानी कोर्ट का एक एक्सपीरियंस ऐसा है कि एक बुजुर्ग कपल अराउंड इन 70s they approached before the Supreme Court. They were fighting for divorce. The Supreme Court justice asked, ये क्या उम्र है क्या यार डाइवोर्स मांगने की? बोले सर क्या करें, we were 35, 37 when we filed a petition and you are taking so much time to get us separated. Why these talks are being made? The reason is there are some matters which are taking so long. तो सारे मैटर्स इतना टाइम ले रहे हैं क्या? क्रिमिनल जस्टिस सिस्टम के बारे में अभी आपने कुछ लेटेस्ट में अगर कोई वीडियो देखा होगा, वी जस्ट डिस्कस्ड, मैं जाऊं मैं चाहे जो करूं मेरी मर्जी. किसी ने देखा है? यस. शेयर नहीं कर रहे काफी लोग डर की वजह से. We need to see these critics in positive sense. तो ये जो क्रिमिनल जस्टिस सिस्टम के बारे में जो चित्र खड़ा किया जा रहा है, whether there is some substance, if yes, what are the factors responsible for it, and what can be the reforms for that. So for this deliberation, we are here. I am from the judicial background, so I will be pointing, I will be making my submission from that perspective. Madam Farhat Khan, she is a doctorate. She has completed her LLM in criminal law. So as an academician, she will be putting her stand. Here churning of mind will take place. Out of this churning, we are here to see some solutions, some reforms. So अभी के क्रिमिनल जस्टिस सिस्टम के बारे में जो कहा जाता है वो क्या कहा जाता है? ह्यूज पेंडेंसी, ह्यूज डिले, अनसर्टेनिटी ऑफ फेट. तो ये जो अनसर्टेनिटी ऑफ फेट है, ह्यूज डिले है, हेवी अरियर्स है, कैन वी से दैट ओनली जुडिशियल सिस्टम इज रिस्पॉन्सिबल फॉर दिस? ऐसा कितने लोगों को लगता है कि ओनली जुडिशियल सिस्टम इज रिस्पॉन्सिबल फॉर दिस? प्लीज हाथ ऊपर कीजिए. कोई नहीं. से स्टेक होल्डर्स कौन कौन है? स्टेट, पब्लिक, एडवोकेट्स, investigation officers, that is police machinery, and government leaders. Each one of these is having its own role in this judicial system. तो ये जुडिशियल सिस्टम में हर एक का रोल कंट्रीब्यूट करके ये सिस्टम बनती है. उल में कहीं ना कहीं कुछ ना कुछ रिफॉर्म्स की जरूरत है. सो लेट अस सी हर फील्ड में कहाँ कहाँ कौन से रिफॉर्म्स की जरूरत है, क्या क्या कॉजेस है. ऐसा कहा जाता है कि a right legal system develops a right society and a right society develops a right legal system. तो ये right legal system के components, constituents क्या क्या है? Yes, कोई बताएगा? Legal system किससे बनी है? कहाँ से स्टार्ट होता है? इन्वेस्टिगेशन ऑफिसर, सरकारी वकील, जज, ये तो तीन है. ओके. क्रिमिनल लॉज एंड जस्टिस रिफॉर्म्स. काफी टाइम लड़के के साथ जब बात करता हूं तो ध्यान में आता है कि यंगस्टर्स का फोकस थियरी पे या थ्योरेटिकल पे ज्यादा जाता है. जस्टिस का मीनिंग क्या है थोड़ा जानना चाहूंगा आपसे. व्हाट डू यू अंडरस्टैंड बाय जस्टिस? यस, एनीवन? अरे यार, ऐसे बच्चे कैसे कर रहे हो आप? ये फील्ड में आ रहे हो. जस्टिस, एनीथिंग विच इज एज पर लॉ इज जस्टिस. इसे हम जस्टिस कहेंगे. एक एग्जांपल दूंगा जो आप सबने सुना है. एक भूखा बच्चा है, उसने चोरी की, फूड की. उसे पनिश करना चाहिए या नहीं करना चाहिए? यस. पनिशमेंट नहीं करना चाहिए या करना? चोरी है तो पनिशमेंट करना चाहिए. मैडम का नहीं कहना है. मैडम क्या है, आपका क्या ओपिनियन है? एक्चुअल सिचुएशन क्या है ये देखना चाहिए. करेक्ट. यस, एनी अदर ओपिनियन? सी वी हैव टू ओपिनियंस. एक बच्चे ने जो भूखा है उसने फूड की चोरी की है. वन पर्सन इज सेइंग कि उसे पनिश करना चाहिए, अदर इज सेइंग कि सिचुएशन देखना चाहिए, उसको पनिश नहीं करना चाहिए. So I suppose that this entire audience is divided in two views. One view is saying that punish करना चाहिए. It means justice के understanding के बारे में भी we are having two views. So I say कि justice का actual meaning क्या है ये हमें समझना चाहिए जब हम justice की बात करते हैं, justice reform की बात करते हैं. तो what is justice? Justice की definition आएंगी. What is ethical, logical, rational in the given scenario? So justice is whatever is ethical, rational, logical and covered in the legal corner. अभी एंशियंट इंडिया में जो जस्टिस देते थे वो क्या होता था कि किंग्स, राजे लोग जस्टिस करते थे. धर्मशास्त्र वेर यूज्ड, and the wisdom of the kings, these two were the paramount factors. Subsequently, in the British era, in 1860, codification started. IPC was enacted in the year 1860. CRPC was enacted in the year 1861. Evidence Act was enacted in the year 1870 to 73. So why this codification was done? To bring certainty. What is IPC? IPC is a offense. तो अभी सर ने बताया था, रमन सर ने, कि क्रिमिनल लॉ रिप्रेजेंट्स द mirror of society's moral conscience. What does this mean? सोसाइटी का मॉरल कॉन्शियस का मिरर क्रिमिनल लॉ है. ये बहुत थ्योरेटिकल नॉलेज हो जाती है, तो हम इसको कॉमन अंडरस्टैंडिंग में समझना चाहते हैं. जो सोसाइटी को लगता है कि सोसाइटी के एग्जिस्टेंस के लिए ये हरकत गलत है, उसे हम क्राइम बनाते. सोसाइटी को लगा किसी को थप्पड़ मारना गलत है, तो थप्पड़ मारना इसे ऑफेंस बना दिए. सोसाइटी को लगा आगे चल के कि किसी की बदनामी करना गलत है, तो डिफेमेशन नाम का एक ऑफेंस आ गया. तो एज सोसाइटी इज इवॉल्विंग, तो सोसाइटी का मॉरल कॉन्शियस जैसा इवॉल्व होता है, वैसा लॉ इवॉल्व होता चलता है, क्रिमिनल लॉ इवॉल्व होता चलता है. इन 1983 498A was introduced in IPC. Before that there was no 498A. तो ऐसा कहा जाता है क्या कि मैरिड वुमन को क्रूएल्टी नहीं थी 1983 के पहले? थी, पर तब तक सोसाइटी का मॉरल कॉन्शियस वहां तक नहीं आया था कि मैरिड वुमन की क्रूएल्टी को ऑफेंस में टर्न किया जाए. सो व्हाट इज क्रिमिनल लॉ? बेसिकली क्रिमिनल लॉ इज सोसाइटी को जो लगता है कि ये गलत है, दैट इज कोडिफाइड, दैट इज formulated, defined, and it is called criminal law. CRPC आपको प्रोसीजर देता है हाउ टू हैंडल इट. एविडेंस एक्ट आपको स्टैंडर्ड्स देता है. अभी अगर समझो मैं कहता हूं कि मेरे सामने एक को पकड़ के लाए, लेट अस टेक एग्जांपल. मैं थोड़ा एग्जांपल्स पे इसलिए जोर देता हूं कि हमारा अंडरस्टैंडिंग उससे डेवलप होता है. ये आप बच्चे यहाँ सब है, आपकी बैग्स यहाँ पे पीछे रखी हुई है. एक स्टूडेंट की बैग यहाँ से चोरी हो जाती है. किसने चोरी की ये पता नहीं है, यहाँ पे सीसीटीवी नहीं है, लेकिन डाउट पे कॉलेज का एडमिनिस्ट्रेशन किसी को तभी पकड़ता है और उसे सजा देता है. अब ये डाउट पे सजा दी गई, अगर समझो उसने चोरी नहीं की है, तो ये सही रहेगा या गलत रहेगा? गलत रहेगा. पूरे क्रिमिनल जस्टिस सिस्टम में जब हम बात करते हैं कि ऑफेंस शुड बी बियॉन्ड प्रूव्ड बियॉन्ड रीजनेबल डाउट, उसका रीजन यही है क्योंकि नो इनोसेंट शुड बी पनिश्ड एंड नो गिल्टी शुड गेट एस्केप्ड. तो अभी क्रिमिनल जस्टिस सिस्टम में हम जो देखते हैं कि बातें होती है कि यहाँ गिल्टी पर्सन छूट जाता है. तो क्यों छूटता है? यहाँ पे लॉ की कमी है, लॉ में रिफॉर्म्स की जरूरत है, कि पुलिस मशीनरी में रिफॉर्म्स की जरूरत है, या जुडिशरी में रिफॉर्म्स की जरूरत है. नाउ आई एम टर्निंग टू रिफॉर्म्स. लेट अस फर्स्ट सी रिफॉर्म्स इन लॉज. अभी लॉ में के रिफॉर्म्स ऑलरेडी आप सबने सुने होंगे कि इन 2023 we have enacted BNSS and भारतीय साक्ष्य अधिनियम BSA. ब्रिटिश कॉलोनियल एरा के क्रिमिनल लॉज को हमने इंडियनाइजेशन किया है. इसमें टू व्यूज हो सकते हैं, कोई बोलेगा जरूरत है, कोई बोलेगा नहीं है. वी शुड नॉट वेल इन, पर उसके जो बेनिफिट्स है, कुछ चीजें जो थी जिसके लिए इन्होंने हमको रिफॉर्म दिए ये एक्ट्स ने, जैसा 0 FIR बाय ईमेल, नो वी कैन लॉज FIR. इनिशियली ऐसा होता था कि कंप्लेंट दिए कॉग्निजेबल, इसमें तो ऑफेंस रजिस्टर हो जाता था. वो गलत भी कंप्लेंट है तो इनोसेंट पर्सन अरेस्ट हो जाता था. अभी लॉ में प्रोवाइड किया है कि अगर ऑफेंस 7 इयर्स तक पनिशेबल है तो प्रिलिमिनरी इंक्वायरी करना मैंडेटरी है, इमीडिएटली अरेस्ट ना हो। ऐसे काफी रिफॉर्म्स बीएनएसएस में दिए हैं, बीएनएस में दिए हैं। बीएनएस में जो रिफॉर्म्स दिए वो कौन कौन से दिए हैं, जैसा एडल्टरी डिलीट किया है, ऑफेंस टू कमिट सुसाइड ये डिलीट किया है। अबे और रिफॉर्म्स की जरूरत है क्या? कौन से एक्ट्स में रिफॉर्म्स की जरूरत है? तो पर्सनली मेरा कहना ऐसा है कि यस, पोक्सो एक्ट में पोक्सो एक्ट में रिफॉर्म की जरूरत है। अभी आप सारे बच्चे लोग थोड़ा ध्यान देंगे बिकॉज इट इज रिलेटेड विथ यू ऑल। पोक्सो एक्ट आप सभी को पता है। पोक्सो एक्ट में क्या है कि चाइल्ड की सेक्सुअल हरासमेंट रोकने के लिए पोक्सो एक्ट आया है इन द ईयर 2012। पोक्सो एक्ट में सेक्शन 3 है पेनिट्रेटिव सेक्सुअल असॉल्ट, जिसमें ऐसा कहा गया है कि इफ एनी पर्सन कमिट्स पेनिट्रेटिव सेक्सुअल असॉल्ट ऑन अ चाइल्ड देन द ऑफेंस इज पनिशेबल विथ मिनिमम 10 years। तो सपोज एक 50 साल का मैन है, वो अगर एक 17 साल की लड़की के साथ अगर सेक्सुअल इंटरकोर्स करता है उसकी सम्मति से या बिना सम्मति से, तो उसे कम से कम 10 साल की सजा होती है। और अगर वही पर्सन 50 साल का पर्सन अगर वही 17 साल की लड़की के साथ 2 बार या 2 से ज्यादा बार करता है तो उसे मिनिमम 20 years की सजा होती है। बाद में उसी में सेक्शन दिया है, सेक्शन 11, विथ सेक्सुअल इंटेंट टू अटर एनी वर्ड or to make any gesture or to make any sound towards a child is also made a punishable offense। अभी मैं आपसे पूछना चाहूंगा, काइंडली लिसन केयरफुली। एक 17.5 साल की लड़की है, 18.5 साल का लड़का है। ये लड़का 18.5 साल का लड़का वो लड़की को कहता है की तू छान दिसतेस, सुंदर दिसतेस, आणि याच्या पलीकडे तो काहीच म्हणत नाही। इसके अलावा वो कुछ भी कहता नहीं है whether this should be an offense or not। yes, एक 18.5 साल का लड़का है कॉलेज में, वो 17.5 साल की लड़की को बोलता है कि तू फार छान दिसतेस, whether this should be an offense or not। ऐसा जिनको लगता है कि ये ऑफेंस है उन्होंने हाथ ऊपर करना है। ओके, सो हमको टाइम का बंधन दिया था, हम टाइम कंप्लीट करेंगे। रिफॉर्म्स में शॉर्ट में हरिडली आई विल से कि पुलिस इन्वेस्टिगेशन जो है, इन्वेस्टिगेशन मशीनरी शुड बी सेपरेट फ्रॉम द लॉ एंड ऑर्डर मशीनरी। The police machinery who are dealing with investigation, they should be given the exclusive task of investigation only, that is in police reform। जजेस के बारे में जो है जुडिशरी में जो रिफॉर्म्स की जरूरत है वो है इंक्रीजिंग द नंबर ऑफ जजेस। लेटेस्ट 15 अक्टूबर को गवर्नमेंट ने 2000 प्लस जजेस की संख्या बढ़ा दी है। अभी और जो जरूरत रहेंगी रिफॉर्म की जुडिशरी में, वो रिफॉर्म ऐसा है कि जजेस की जो पर्सनालिटी चाहिए, जज शुड नॉट बी अ पर्सन हु नोज ओनली द लॉ। जज का रोल जो है वो 2+2=4 नहीं है। जज का रोल है उसको पूरा सोसाइटी का नॉलेज चाहिए, साइकोलॉजी का नॉलेज चाहिए। तो जुडिशरी में रिक्रूटमेंट में थोड़े से इम्प्रूवमेंट की जरूरत है। जो सिर्फ याददाश्त करके एग्जाम पास होते हैं, इंटरव्यू में सिर्फ लीगल सवालों के जवाब देते हैं, उनको अगर जज करके सिलेक्ट किया जाता है तो वो सोसाइटी के प्रॉब्लम्स अगर प्रॉपरली समझ नहीं पाता है तो वो हैंडल भी कैसे करेगा। तो ये रिक्रूटमेंट प्रोसेस में अगर थोड़ा बदलाव आता है और एक सोशली डेवलप्ड साउंड वर्साटाइल पर्सनालिटी का अगर पर्सन जज बनता है तो वो जुडिशरी के लिए काफ़ी लाभदायक ठहरेगा। ये जुडिशियल रिफॉर्म जुडिशियल इंस्टीट्यूट में ज़्यादा काम में आएंगे। तो हमारा टाइम हो गया है, हम आपसे विदा लेते हैं। आप सभी लोगों ने सुने, पेशेंटली सुने, जबरदस्ती सुने। कौन सा? अरे किसकी सुनो ऐसा सवाल रहेगा? सर का कहना है कि क्लोज करना है। ये होने के बाद कंप्लीट करेंगे कभी। So I am very much thankful to all of you for listening me. I am thankful to the organizers for giving me this opportunity to express myself before you audience. I will again say that this topic is very good. Yeah, you all should take keen interest in this topic. Thank you very much.
Thank you so much, sir, for your inspiring address. Your reflection on the spirit of justice and reform have set a meaningful tone for the seminar ahead. Now, to again introduce the central theme of the seminar, may I invite Dr. Rahul Visaria, former Head of Department, Faculty of Law, Allahabad Degree College, Prayagraj, to present the introduction of seminar theme. Make presenter.
Just give me a minute. I'll call Bisaria sir. He's saying that he's trying to switch on his camera. Just give me a moment, please. जी सर, you are visible now. सर आपका माइक शायद बंद है. बिसारिया सर. सर आपका साउंड नहीं आ रहा है. बिसारिया सर. सर आपका साउंड, आपका कैमरा हैंग हो गया है सर शायद.
नहीं सर.
यस सर, आपका वीडियो आ रहा है. बिसारिया सर आपका वीडियो आ रहा है अब, लेकिन ऑडियो नहीं आ रहा है. नो सर, सब ऑडियो नहीं आ रहा है. सर आप मोबाइल से ज्वाइन कर लीजिए. Bisaria sir. सर आपका ऑडियो नहीं आ रहा है.
बोलो मुक्ति मैम. हेलो.
Hello. Yeah. Ma'am, there is some problem at the in the technical error in the mic of the instrument which sir is using. So I think it's not possible for him to continue with his speech. We can proceed with the inaugural ceremony as as
Okay,
planned.
ma'am. Okay. Okay, ma'am. Okay.
Yeah.
To mark the conclusion of the inaugural session, I now request Mr. Gaurav Rakulkar, Assistant Professor, School of Law, G.H. Raisoni, Skilltech University, to deliver the vote of thanks.
Good morning, all. Honorable Chief Guest, respected dignitaries, distinguished speakers, colleagues, and dear participants. It is my honor and privilege to propose the vote of thanks on this momentous occasion of National Seminar on Criminal Law and Justice Reforms. At the very outset, we extend our heartfelt gratitude to our Chief Guest, Honorable Shri Bhushan Shirsagar Sir, Registrar Administration, Honorable High Court of Bombay, Nagpur Bench, for gracing this seminar with his esteemed presence. Sir, your enlightening address and thoughtful reflections on evolving dimensions of criminal law and justice reform have truly enriched our understanding. Your insights on the role of judiciary, administrative efficiency, and need for progressive interpretation of law will surely inspire both scholars and practitioners present here today. Your words have provided not only directions but also motivation to pursue the ideals of justice with renewed commitment and ethical responsibility. We are deeply grateful for the time you spared from your demanding schedule to join us and make this seminar truly memorable. We also extend our sincere thanks to all distinguished chairpersons, co-chairpersons, and speakers who contributed their valuable perspective and engaged us in meaningful discussion. Our gratitude to the organizing team of both institutions, the School of Law, G.H. Raisoni Skilltech University, Nagpur, and the Faculty of Law, Allahabad Degree College, Prayagraj, for their tireless efforts in making this event grand success. A special word of appreciation goes to all participants, paper presenters, and attendees, both offline and online, whose active engagement made this seminar vibrant and intellectually stimulating. Lastly, we thank our management, faculty members, and student volunteers for their constant support and seamless coordination throughout the day. Once again, on behalf of organizers, I express our deepest appreciation to Honorable Sri Bhushan Sagar Sir for his gracious presence and inspiring words. Thank you, sir, for being with us today and for adding immense value to this academic gathering. Thank you all.
Thank you, sir. We thank everyone for their gracious presence. But please be seated for first presentation afterwards. Mukti ma'am. Hello, am I audible? Mukti ma'am. Mukti ma'am, am I audible? Hello, Mukti ma'am.
जी अनुष्का मैम।
मैम हम पहला टेक्निकल सेशन स्टार्ट कर रहे हैं। हमारे पास एक आए हैं प्रेजेंटेशन करने ऑफलाइन मोड में, तो वो
हाँ।
यहाँ पे प्रेजेंट करने वाले हैं, तो शुरू करें हम।
Yeah, as I can see, the chairperson of the first session has also joined the link. So I'm asking the moderator to begin the session. Deesh sir?
Yes, ma'am. Yes.
Yes, ma'am. Am I audible, ma'am?
Yeah. Kiran ma'am?
Yes. Am I audible to everyone?
Yes, ma'am.
Yes,
Okay.
both of
Yes.
you are audible.
Okay.
Please invite our chairperson. All the best.
Yes. So good morning, everyone. My name is Deesh Kusia. I am from Allahabad Degree. I'm an assistant professor in Allahabad Degree College. And I'd like to invite our co-chairperson, Dr. Kiran Singh, to invite her. Ma'am, please.
Thank you, Deesh. Good morning to one and all. Myself, Dr. Kiran Singh, Assistant Professor, Allahabad Degree College, Faculty of Law. Good morning again to one and all. It gives me an immense pleasure to extend a warm and a cardinal welcome to our distinguished guest, Dr. Santosh Kumar Sharma, and to all the esteemed participants gathered here for intellectually enriching session on substantive criminal law reform. Dr. Sharma is an eminent academician from Himachal Pradesh National University, Shimla, whose illustrious career has stand as an inspiration for all legal fraternity. A holder of LLB and LLM degree from Mahatma Gandhi Jyotiba Phule Rohelkhand University, Bareilly. Dr. Sharma has earned his PhD in law from Faculty of Law, University of Delhi. With extensive teaching and research experience in constitutional law, criminal law, presently he serves as the director of the Center for Alternative Dispute Resolution and Professional Ethics, convener of Moot Court Committee, and in charge of a placement committee at Himachal Pradesh National University, Shimla. With over a decade of teaching and research experience, Dr. Sharma has taught and published extensively in areas such as constitutional law, criminal law, media law, and intellectual property rights. Now, the theme for the today's session is, as discussed, substantive criminal law reform. It holds a profound contemporary significance in an era which is marked by rapid socio-economic changes and technological advancement. Our criminal justice system must evolve to remain just, equitable, and effective. Substantive law reform in criminal law aim not only to modernize outdated provision, but also that our legal system align with constitutional morality, human right, and restorative justice principle. The focus is on redefining the balance between individual liberty, societal protection, and thereby simplifying the procedure complexity which are there in the system and incorporating a gender sensitive reform, victim right, alternative mechanism for justice. So as we deliberate today, guided by Dr. Sharma's scholarship and insight, we look forward to a meaningful discussion that can contribute towards shaping a more responsive and humane criminal justice reform for our nation. Once again, I extend a heartfelt welcome to Dr. Santosh Kumar Sharma and to our distinguished delegates, participants. Let us engage with open mind and share a vision for a reform justice system. Welcome, sir.
Thank you so much for your generous introduction. Am I audible?
Yes, sir, you are audible.
Okay, thank you so much. So, first of all, I congratulate the organizers to have a discussion in form of this national seminar, because what the approach we find today, that in the name of emerging subjects, new areas, many fundamental subjects are going missing. Like family law, constitutional law, criminal law, we have more and more conferences, seminars on the emerging areas. That is not bad one. But the concern is evergreen, that fundamental subjects remain fundamental. However, because of the new criminal laws, we find that number of programs are being organized. But the timing you have chosen for this national seminar, this is a good one because we have almost completed or on the verge of completion of 1.5 years for this. And when this was about to be commenced, I remember those days the kind of apprehensions people had in their mind. In many programs and the sessions I had with the judges and the other administrators, but practically we find as a teacher and as an administrator that some of the changes which have been brought into in the time to come, people will be apprised with them and in a better manner, but substance has not been very much changed. So criminal law and justice reforms, these two words when conjuncted with "and", what we have to think about the criminal law. First of all, very well known two phrases, two terms which we all speak in our daily life. One is crime and another is offense. Okay. So I think every student of law, each of us as a teacher, we should be very clear about this conception, social construction, legal technicalities or legal restraints we have, because there must be a difference in framework of the law, in response to the people, and fixing the liability of the person when a person is committing murder and a person is traveling without a ticket. Both may be termed as the offense, but the liability when being fixed, it will very much depend that how society respond to that. So that is how that these two terms mostly we refer. Offense is considered to be the larger one. Crime, the traditional approach, considered to be those which society does not like wear or does not have the capacity to wear with. So society cannot sustain if those activities are taking place in the society. So in this background, what we find, but nowadays we find that we have many such kinds of the regulations, rules, and others. Like spitting in a metro is an offense. Plucking a flower from the garden is an offense. So first of all, as a law student or law scholar, we have to differentiate in mind. So how we can differentiate? We can differentiate on the basis of that what ultimately law wants to achieve by declaring any act as the prohibited one, forbidden one. Okay, so those essential elements in this national seminar, I suppose, I believe that papers selected, the presentation will highlight on those basic aspects of the criminal law and what are the initiatives being taken, whether they are appropriate, if something really required, not merely the cosmetic suggestions, then they must be welcome. So I welcome all the participants, all the researchers who are going to present the paper. uh, a lot of the things are there, a lot of issues may be there to discuss with, but the priority I think should be given with my co-chair, that priority be given to the presenters. That is why we may start with, and we may inform the on the time division to them, the questionnaires and other. Okay, thank you very much for inviting me. So we are very hopeful that some of the presentations would really be enlighten us.
Thank you so much for this insightful and informative speech, and which gave us a great start for this session. So now I'll request the participants to start. But first, I request all the participants to adhere to their list and the schedule that has been given, and strictly adhere to the time limit, because we are in dearth of a little bit of time. So firstly, I'll request Ms. Sampada and Mr. Anirudh to present their paper.
Sir, am I audible to you?
Yes, ma'am.
Sir, this Sampada is going to present physical mode. So can she start here in the auditorium? Is that all?
Yes, ma'am.
Okay.
Yes, ma'am.
Good morning, everyone. My name is Sampada Bell, and here's my co-author, Anurag Pachkole. Am I audible?
Ma'am, the
Hello?
voice isn't clear. I think we should use the other mic.
Hello?
Yes,
Hello?
you're audible now.
Okay. So, sir, our topic is BNSS and the promise of speedy justice, a critical appraisal of procedural reforms. So, we have chosen this topic because we want to evaluate whether BNSS has the potential to fulfill the constitutional mandate of Article 21 of Indian Constitution, as Indian criminal justice system has long struggled with the pendency of cases, procedural delays. Therefore, critical study will help assess whether the provision in BNSS are sufficient to tackle all the issues. The first procedural law came in the year 1861. Its main focus was just to maintain law and order so that the Britishers can still control over India. The second procedural law came in the year 1898, but it also doesn't change the situation, as there was a lot of paperwork has to be done before getting the justice. Later, CPC was passed in the year 1973. No doubt it tried to fill the gap between the, because it tried to fill the gap existing because of earlier laws, but it does not meet the expectation of the constitution, because there were still a lot of cases pending because of which innocent people were suffering. Therefore, the BNSS was passed to reform the old criminal justice procedure. BNSS has reformed the procedural law for ensuring speedy justice and to incorporate the digital processes. The objective here is to strengthen the criminal procedure for ensuring citizen-centric approach, also for ensuring speedy justice. Adaptation of electronic technology is also adopted because for conducting trial of accused by electronic means. It tried to strengthen the accountability, as people were losing faith in criminal justice system earlier because of pendency of cases and procedural delays. BNSS has adopted new rules for use of technology. Now under BNSS, FIR can also be made through electronic means. Also, the digital record has to be maintained strictly. For speedy trial, courts have to conduct the court hearings and hearing of testimony or taking of testimony of witnesses remotely through video conferencing. Under section 193, it has been incorporated that now any investigation has to be completed before 90 days from the trial. Also, now FIRs can be consolidated for expediting the trial, but only those FIRs where incidents are of same nature. Earlier in CRPC, we have seen that the use of technology as used under CRPC was very minimal, but in this BNSS, the use of technology has been extended. Also, the time foundation, which has been said, was absent in CRPC, but now it is being introduced, and CRPC was very weak in relation to victim-centric approach, but BNSS has been made for so that we can we can make citizen-centric approach very strong. Then rest of the paper will be covered by my co-author.
Let's move forward. There are a lot of earlier decisions which stresses that speedy justice is a part of Article 21 of Constitution. In the first case of Husainara Khatun was a state of Bihar. The SC held that constitutional principle must be adhered to by the procedural law, including BNSS. Next, in the case of Antony versus R.S. Nayak, the Supreme Court established certain criteria to promote justice. And at last, the case of Ramchandra Rao versus state of Karnataka, the court stated to make a balance or rigid of accused with the need for quick justice. BNSS has been introduced to strengthen digital efficiency and the judiciary strictness on delays. Next, the BNSS mandates strict deadline for trial and investigation with the use of electronic filing, so that digital transparency should be maintained and it should be easily accessible. Also, it promotes victim participation throughout the judicial process for enhancing their rights. BNSS also foster better cooperation between police and judiciary for case management. The BNSS has set time foundation for police investigation and court procedure, but police still have the power to keep the suspect in custody for 15 days. BNSS has been applied throughout India, but some of the states lack technological advancement. BNSS came with the idea of strengthening the speedy justice, but there is no punishment for officials if they delay the process. There is also need for police and judicial training for adaptation of technology in investigation and trial procedure. Our suggestion is that the government should invest in courts digitalization and technology so that it will help the procedure, the victim, and the accused to get speedy justice. And the digital training program for courts and police should make mandatory. Also, daily legislative review is necessary, which will help our laws for betterment. And in conclusion, I would like to state BNSS is a bold and necessary step toward modernizing India's criminal justice system through digital reform. It promises faster, transparent, and more citizen-friendly procedure, but by setting clear timelines and integrating technology like EFIR and video trial. However, the true success of BNSS depends on strengthening digital infrastructure, providing thorough training for police and judiciary, and enforcing accountability to ensure both speed and fairness in justice delivery. Consistent effort and systematic reforms are essential to realize its full potential and move beyond legacy delays toward efficient, fair, and accessible justice for all. Thank you. Thank you for giving us this opportunity.
Thank you so much, Ms. Sampada and Mr. Anirudh. Now, next participant is Ms. Anushka Paul. I'd like to request, please join and start. Ms. Anushka Paul.
Am I audible and visible?
Yes, ma'am. You're audible.
I would like to present a PPT for my paper. Is that okay?
Yes, please.
Yeah. Is it visible?
Yes, it is.
Okay. Good morning, everyone. My name is Anushka Paul, and the paper that I would be presenting is, my topic is rather, From Colonial Chains to Modern Justice, India's Revolutionary Criminal Law Overhaul of 2024. Now, first, for over a century and a half, our criminal justice system functioned under laws by the British, laws that were never meant to serve the people of India, but serve the interest of colonial rulers. The year 2024 therefore marks as a profound constitutional moment. The replacement of these colonial era laws with legislations that reflect our sovereign, democratic, and modern Indian spirit. This reform is far more than a technical legal amendment. It is a civilization statement, a declaration that India's justice system now belongs fully to its people. It reflects a transformation from control to care, from punishment to protection, and from imperial authority to constitutional morality. As we explore these changes, we will see how India has moved from the chains of colonialism to a justice system that truly embodies the ideals of liberty, equality, and dignity enshrined in the Constitution. Now, about the great legislation transformation. The year 2024 will forever be remembered as a turning point in India's legislative history, a moment when we decided to finally step out of the shadow of colonial laws. The three major British criminal laws which governed our system for more than 150 years have now been replaced. Number 1, the Indian Penal Code 1860, replaced by the Bharatiya Nyaya Sanhita, that is BNS, redefining the principles of criminal liability. Number 2, the Code of Criminal Procedure 1973, replaced by the Bharatiya Nagrik Suraksha Sanhita, that is BNSS, reimagining the machinery of justice delivery. And number 3, the Indian Evidence Act 1872, replaced by the Bharatiya Sakshya Adhyam, that is the BSA, updating the law of proof for the digital era. Together, these three enactments form the new trinity of criminal law, seeking to maintain the justice speedy, transparent, and accessible. The colonial codes were rooted in the 19th century British context when India was seen as a territory to be ruled. The 2024 codes, however, are grounded in the 21st century Indian reality, a republic that values citizens' rights and constitutional ethics. It is not merely a change of names or sections. It is philosophical revolution, redefining how the state interacts with its people through lens of justice. Now moving on to the colonial shadows, the legacy that lingered. To truly appreciate the reforms, we must understand that we have left behind a justice designed to rule, not to serve. The British drafted the Indian Penal Code and the Criminal Justice Code to ensure strict control over its Indian subjects. The system was hierarchical, bureaucratic, and fear-based. It treated our citizens as objects of governance and as bearers of rights. Even after independence, these colonial structures persisted. While our constitution in 1950 gave us fundamental rights, the criminal justice machinery still reflects the mindset of colonial patronism, emphasizing order over liberty. As a result, even decades after independence, trials dragged on for years, under trials languished in prisons, and ordinary citizens feared the police rather than trusting them. The Supreme Court's landmark decision in Maneka Gandhi versus Union of India 1978 redefined Article 21, asserting that no person shall be deprived of life or personal liberty except according to a just, fair, and reasonable procedure. This expanded interpretation laid the Constitution foundation for reform, but the laws themselves remained outdated. The 2024 reforms are therefore not just legislative corrections, they represent the long overdue fulfillment of the promise of independence. Act a justice system of the people, by the people, and for the people. Now, the four pillars of BNSS reform. The Bharatiya Nagrik Suraksha Sanhita (BNSS) introduces transformative principles that aim to make our criminal justice process citizen-centric. Let's look at its four foundational pillars. Number 1, timeliness. For decades, India's justice system was infamous for delays. I would like to be excused for a minute. Sorry. The BNSS sets specific time limits for investigation and filing of charge sheets, ensuring that cases move forward within minutes. Can I be excused for a minute?
Yes, please. Yes, please. If you want, we can reschedule it. Like next, you can present next if you need time. Now, not audible. Your mic is still off.
Am I audible now?
Yes, you are audible.
Yes.
Are you fine?
Yeah, I'm fine. Thank you. Just a bit under the weather. Yeah. So I was talking about the timeliness. For decades, India's justice system, but infamous for delays. I guess I won't be able to present right now.
Sure, we can for later. We can start with another participant. So,
Yes, you can give your concluding remarks later on. So we may ask for the next one.
yes, sir. Thank you. So I'd like to invite Dr. Sandeep Bedi and Dr. Arun Sharma to present their paper. Sandeep and Dr. Arun.
Good afternoon to the August panel. Please tell me if I'm audible.
You are.
Please give me a bit. I would like to share my PPT if I can.
Ma'am,
Okay, I have to be made as a presenter first, is what it shows me.
you can share it. There might be an option.
I can find the option of share. It says you can't share content unless the host presenter makes you a presenter.
Okay, ma'am, I'll look into it, ma'am. Just a minute. Just a minute, ma'am. We're giving you, ma'am.
Sure.
Just one.
I mean, if it's taking time, I can start right now. No problem with that.
Sure, ma'am. If you could, we can start later on if it's possible. We'll give you.
Sure. Okay. So I'm visible, right? Am I visible?
Yes, ma'am, you are.
All right. Thank you so much. Well, the topic for today is transforming the legal landscape, a critical study of women's and transgenders' rights. So I will be dealing with how this topic is under evolving with respect to the Bharatiya laws. And the presentation will be done by me, Dr. Sanjum Bedi, and the research work is done along with my co-author, Dr. Arun Sharma. Well, to start with, we know that crime-free society is a myth, and the criminal law reconstruction that we all have gathered here and we've been speaking since the inaugural. This is not only the renovation of the criminal law, but it reinforces the commitment to safeguard the dignity of women. Anytime we come up with a law, we make it sure that it resonates with the changing needs of the society. Now, this presentation today will help us, however, to understand how much it has resonated. So, more of it would be a critical analysis of the new laws that have come up. But before that, I will take a little time to explain that how we reached to this level. So earlier, there was no distinction in the earlier times. I'm talking about the early civilizations. There was no distinction between the civil laws and the criminal laws. It was the Norman invasion of England when we started making this distinction. And the first codified law came up with the Sumerian. So the idea of the police system came up with the Europeans when they began to manage and control the entire civic society. They found that there has to be a body, a managerial body, and that was the origin of the police system. Coming on to how we got our IPC, because in 1833, the British government appointed Indian Law Commission. And this Indian Law Commission took a lot of time because it was appointed in 1833. And there were three objectives of appointing the Indian Law Commission. One, to understand what Indian laws were, what type of laws would be effective in India, and then the jurisdiction of these laws. So it submitted a report, and this IPC was a conclusion of the report. Actually, it can be said it was submitted by Lord Macaulay in 1837, and it took about a lot of time. In 1860, we got our IPC. Almost 30 years of heavy deliberations were included in this.
I'm sorry to interrupt, but I think now you can present if you have anything.
Okay.
Thank you.
Please let me know if I've shared it well. If you could see the slide, sir.
Yes, ma'am.
Yes,
It's
ma'am.
visible. We can see it.
So we can all see the powerful figure behind the Indian Penal Code. Sir Macaulay is there, and I have already covered up this slide. And I was just about to tell that in 1860, we got our IPC, and just in 1861, we got our first draft of the Criminal Procedure Code. Because the entire presentation revolves, the paper that I have submitted revolves around the women. So I would start with the most demeaning job that was associated with them when the women started working as prostitutes in brothels during the colonial times. And these brothels were called as chaklas. And these women could consort only with the soldiers. And what was the entire episode that was associated with this? That because in this entire military panel, the heads did not want that homosexuality should prevail in this entire system of military. Therefore, they needed women to consort with the soldiers, and these women were licensed women, licensed sex workers. So from here only the structural inequality started that pushed women into prostitution. And the British Raj was also convinced that with sexual contact with women, the British army would, stay away from sodomy. So from here, the concept of licensed prostitution started. Moving on to the exact point where I want to hit is the section 377 being abolished under IPC. My point to be proven is that we have abolished section 377. However, if we could critically analyze in a milder sense, 377 non-consensual, consensual activity under this should have been abolished, because with abolishing the entire root of 377, what we have done, number one, the women who are married and who face the forceful anal intercourse can now not go to the court. The only remedy that they are left with is divorce on the basis of plurality. Earlier they had this remedy, but now we've abolished it. Secondly, the transgenders who face the ingredients under Section 377, the minor males have the POXO Act for them, but the adult males, if a male forces him over another adult male, there is no section under which he can take the rescue. So this is why I believe that abolishing Section 377 could have been filtered out, and it could have been resonated well when we are trying to deploying a new law, which I do not appreciate that it is okay. We have done it. We have moved away from colonization, but if we very peculiarly take into account certain things, for example, I have covered in my research questions, which will give you the entire crux of my presentation. Do new criminal laws reform the laws for the protection and safety of the women, or it is just repackaging? I do not believe that it is just repackaging. It has done a lot. We have added Chapter 5 in BNS, which is for the women and children's protection. But if we talk about marital rape, which is a highly debatable issue already, why is it that in BNS we are raising the bar of age to 18, which means earlier, if marital rape was committed to a wife who was 15 or under 15, the husband could have been punished. Now we are raising the bar to 18. Why? Reason, because under Child Restraint Marriage Act, the marriageable age is 18. The adult age of marriage in India is 18. Therefore, we have this theme onto this. And secondly, if we have raised the bar to 18, why is it that we cannot name it as marital rape? What is prohibiting us? What is forbidding us in doing that? What is the delay? There are other countries who are having it. However, we are using the word wife in the provision. The provision of the BNS stipulates as the word wife, and the same was there in IPC also. But deciphering it completely we are a few steps back to this, and I hope in the next few decades we could do that. Did the legislatures miss a crucial opportunity to address the issue of marital rape, as I've just addressed it right now? Is the definition of rape under BNS still specifically gendered? Of course, because biologically, as the vast dimensions, exhaustive dimensions of rape we have been covering, now it is not only the contact of the sexual organs. There's a lot of things, other things that have been inclusive to that. So why not? Why not? Why can a female not become an accused to this? Is my point. Is the inclusion of transgenders a step towards equality? Is it really? Is only Section 2, subsection 10, if it's covering transgenders as a person? Have we actually removed the taboo to this? Because Transgenders Act to pehle bhi tha. Transgenders Protection Act pehle bhi tha. Initially we had it, where it had a very flawed definition. The transgenders can be designated as somebody, but that act did not work well for transgenders. Now, in including transgenders under Section 2, subsection 10, I mean, have we actually done good to them? Does the removal of Section 377 IPC result in vulnerability of non-minor males, transgenders, married women, animals to forced anal sex? I've already covered this point. I'll take a few more minutes to complete it. Moving on to Section 69 of the BNS, which introduces a very important provision regarding sexual intercourse not amounting to rape with a woman by employing deceitful means or by making a promise to marry a woman without an intention to fulfilling the same. This is one such point that I'm extremely elated with, on the false pretext of marriage. And the deceitful means, is inclusive of inducement, false promise of employment, promotion, marrying by suppressing the identity. Not only this, sexual harassment has also been covered under Section 67 of the BNS. And I think this is another important section which has been covered in BNSS. The provision that stipulates here is that a rape victim now can get her statement recorded at her own residence or in the place of her choice, as far as practicable by a woman police officer. So also the electronic means using mobile phone can be used here. I'll very quickly make the August panel to go through the other slides. I will not take much more time because I've covered all of these aspects here. Just a few seconds more to show that this entire diagrammatic view has been covered in my presentation, in my paper, research paper. There's a lot more to this. I have just added one figure which demonstrates that the majority of the people who are aware of the replacement of the 3 criminal laws, where figure 2 demonstrates that around 80% of the people believe that such a replacement will be useful for the society. That's all from my side. Thank you so much for patient listening.
So much, ma'am. Now, next, I'd like to invite Miss Akshara to present with the paper.
I would like to request the August panel, if they have any questions, I am all ready to answer them. Okay, thank you. Thank you so much.
Thank you, ma'am. Sorry, I'd like to request Dr. Shalini Tyagi and Miss Namita Jha to present their paper.
Good
Dr.
morning, sir.
Shalini Tyagi.
Sir,
Yes,
I'm Namita Jha. I will be presenting my paper. Am I audible?
Sure.
First of all, am I audible? So,
Yes, ma'am.
I would like to present my paper. If there is any permissibility for the sharing the PPT, so that I can
Ma'am,
share my PPT.
you can start, ma'am. You can try.
Yes, ma'am.
and share it.
You can present. I made you presenter.
Okay. Is my PPT visible here? I don't think so.
Yes, your screen is visible.
I will take just 1 minute more.
Ma'am, if you could just open your PPT in the background and then start sharing and switch it back.
Yeah, sure. Actually, yeah, sure. Oh. Actually, there is some problem. I'm not able to share the screen of PPT.
Ma'am, we can start without the PPT also, if you're okay with it.
Okay. So here, my my presentation, which is basically focuses upon the 3 major issues, which are false rape and accusation cases and domestic violence accusation cases, and the third is under trial crisis. So our paper addresses the credibility crisis of India's criminal justice system, once meant to protect liberty but now struggling with inefficiencies and misuse. So already discussed, 3 critical issues are misuse of protective provisions, false rape and domestic violence accusations, and the under trial crisis with over 75% of prisoners awaiting trial. The Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksh Adhiniyam, which represent India's legislative shift toward Indianized criminal laws, However, still the question arises, can these reforms effectively curb procedural delays, misuse, and imbalance? The study emphasized that justice reform requires systematic change, not just new statutes. I will be next, we'll go forward with research objective of this paper to critically examine how the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam addresses misuse of protective laws and under trial justice, and to assess whether these reforms ensure fairness, accountability, and constitutional morality. So I will be going toward with my first point, which is first point of this particular paper, is problem of false rape accusations, misuse, and moral panic. So there are false accusations distort, actually false accusations distort justice, damage reputations, and dilute genuine victims' credibility. We usually see जो genuine victim होता है वो कभी कभी उस पर भी ये जो false accusation है वो उस पर adversely affect करते हैं. Then BNS obviously covered from section 63 to 79 retains IPC rape provision but lacks safeguards against malicious complaints. There is this very good landmark case of Deepak Gulati versus State of Haryana, in which the court distinguished between consensual sex and rape. And there is this another case, Mahmood Faruqi versus State and City of Delhi, which is context-based evaluation of consent, where court have to evaluate all the scenario while discussing the problem of this false accusation in rape cases. And there is this another aspect of media sensationalism, sensationalism and societal bias create a presumption of guilt even before trial. So this is basically the third issue where media plays the very important role कि आप जो हमारा फॉल्स एक्यूजेशन होता है वो कभी कभी मीडिया के बेसिस पर भी उस पर्टिकुलर ट्रायल को अफेक्ट करता है. And there is this false in police data is not legally defined. So there is this problem of incident reported by the police also, where the weak evidence or withdrawal are not necessarily fabrication, but police data plays an important role. And then there are proposed reforms where introduce a statutory provision for malicious prosecution, like strict enforcement of Anish Kumar and State of Bihar, pre-arrest scrutiny, and gender sensitivity and evidence assessment training for like police officers, judges, and other. And now toward my second point, domestic violence misuse within protection. So the Protection of Women from Domestic Violence Act 2020, 2000 Section 498A IPC BNS were designed as protective laws but are sometimes misused for revenge or property dispute. Today's violence. Now there are many landmark cases. Sushil Kumar Sharma versus Union of India, which in which court warned against misuse of 498A or section 85 of BNS. And there is this another case of Rajesh Sharma versus State of UP, advocated for safeguard against false complaints. And there is this another important case of Suman Mishra versus State of UP, in which this case is stressed upon specific credible allegations, not omnibus claims. So here again, the challenges in this particular point is that there are many vague allegations, wrongful arrests, and social stigmatization, where Sometimes there are property issues and very personal reasons are there to file false allegation in these cases. तो इस वजह से जब कोई इस तरीके के फॉल्स एलिगेशन होते हैं तो ऑब्वियसली दैट अफेक्ट्स विक्टिम आल्सो सो दे ऑब्वियसली erodes the faith of genuine victims claims. And there are these recommendations where mandatorily preliminary scrutiny before issuing protection orders. जब कोर्ट प्रोटेक्शन ऑर्डर इशू करेगा तो उससे पहले मैंडेटरी प्रिलिमिनरी स्क्रूटनी होना बहुत जरूरी है. And gender neutral domestic violence framework, एक framework which is gender neutral and penalizing for proven false complaints under 211 IPC. Malicious prosecution जिसके अंदर penalization of proven false, अगर कोई false complaint prove हो जाती है तो उसके अंदर एक penal provision भी होना चाहिए to protect these false misuse of this particular provision. And judicial training and awareness, obviously, again for the recommendation for responsible application of this particular provision. Now, again, I will move towards my third topic, which is under trial prisoners, the crisis of delay and denied liberty. कई सारे केसेस में ऐसा होता है कि प्रिजनर्स जो होते हैं वो काफी सालों तक अंडर ट्रायल रहते हैं एंड अकॉर्डिंग टू एनसीआरबी डेटा ऑफ 2023 ईयर 2023 77% of prisoners are under trials. Many exceed maximum sentence term for alleged offenses, which is basically constitutional right, which is Article 21. ये उसका clear violation है, which says a right to life and personal liberty and presumption of innocence also affect. And there is this landmark cases which obviously establish the right to speedy trial, which is Hussainara Khatun versus State of Bihar. And there is this provision of 479 of BNS, which allows release on bail after serving half the maximum sentence. अगर half of the maximum sentence cover हो गया under trial person का, then they are allowed to release on bail. And moving forward, the problems.
Ma'am, I request you to please conclude because we are little short on time.
Okay, sure. So I have almost covered all the topics. So, okay. So I will conclude this by after BNS and BNSS aim to Indianize criminal law, but this legislative modernization must translate into ethical enforcement, gender neutrality, and procedural discipline. The guiding philosophy must shift from colonial punishment to constitutional compassion, prioritizing truth, fairness, and human dignity. So I would finally conclude my all the papers presentation. Thank you so much.
Thank you, ma'am. Now next I'd like to invite Ms. Akshara to present a paper. Ms. Akshara Sadi.
Am I audible? Yeah, I just need to share my PPT.
Sure, ma'am. 1 minute.
I need 1 minute. I'm just sharing it. It shows that the co-host is not allowed to share my content. Could you please?
Yes. Yes,
Yeah.
ma'am. Yes, ma'am. Just one.
Okay.
Ma'am, I made your presenter.
Okay. Yes.
Okay.
I hope my presentation is visible.
Yes, ma'am. We can see it now.
Yeah, okay. So, just a minute, sorry. So, yeah, I hope my PPT is still visible. Is it okay?
Yes, ma'am, it is all right, ma'am. We can see it.
Okay, thank you so much. So, today I'm going to talk about today I'm going to deal with the topic criminal law transition in India, a paradigm shift or familiar record. So, as we all know, this India's criminal justice system, long burdened by the vestiges of colonial era legislation, underwent a seismic transformation on July 1st, 2024. And the enactment of BNS 2023, the BNSS 2023, and the BSA 2023 marked the repeal of the Indian Penal Code, CRPC, and Indian Evidence Act. And the proponents hailed this overhaul as a decolonization of the legal framework, emphasizing justice, that is nyaya, over punishment, dand, and aligning the system with contemporary societal needs. And these laws passed by the Parliament on 21st December 2023 after a contentious process involving withdrawal and reintroduction following the scrutiny by the Standing Committee on Home Affairs, represent over 190 amendments, 20 new offences, and a restructured approach to criminal adjudication. So in this paper, I'm critically assess the reforms, comparing old and the new provisions, evaluating impacts, and highlighting challenges, drawing on legal analysis, judicial commentary, and empirical insights. So when talking about the historical context, that is from the colonial codification to the modern reform, as we all know, it is drafted, the IPC is drafted by Lord Macaulay in 1860. It was a tool of imperial control, prioritizing order of equity with vague provisions like sedition, which was dealt under Section 124A of the IPC, that stifled dissent. And the CRPC, amended in 1973, governed the procedures, but was criticized for delays, with over 4.4 crore pending cases since 2023. And the Indian Evidence Act from 1872 lagged in recognizing electronic evidence, ill-equipped for a digital age. So the post-independence amendments patched these gaps, but systematic inertia persisted, with conviction rates hovering at 45 to 50% of serious crimes. And the 2023 reforms emerged from a national dialogue initiated in 2020, culminating in bills introduced on August 11, 2023. Withdrawn amid protest over rush passage, they were reintroduced on December 12, incorporating some standing committee suggestions, such as special procedures for organized crime. And next, regarding the substantive reforms, that is the Bharatiya Nyaya Samhita, the BNS versus the Old Indian Penal Code. So when talking about this topic, the BNS consolidated offences into 20 chapters, reducing sections from 511 to 358, and introduces 20 new crimes while repealing 19 provisions. And this key reform is the abolition of sedition, that is IPC section 124A, which is replaced by section 152 of BNS, which targets acts endangering sovereignty, unity, and integrity like secessionism or armed rebellion, omitting vague disaffection. And this aligns with the Supreme Court's 2022 stay on sedition, potentially curbing misuse against journalists and activists. However, critics argue Section 152 as a broad, subversive activities could enable suppression echoing colonial intent. And the new offences address modern threats, just like Section 111 defines organized crime, which was absent in IPC, which is punishable by 5 to 10 years. And Section 112 tackles petty organized crime like chain snatching up to 7 years. And Section 130, which incorporates the UAPA like terrorism provisions, including funding and recruitment. And the cyber crimes gain prominence with sections 149 to 153 covering identity theft and digital forgery, filling IPC's gaps in section 463 to 477A. And the gender-based violence sees enhancement, that is rape of minors under 18 now mandates the death penalty, section 70, expanding the provision of section 376 under IPC. And section 69 introduces deceitful sexual intercourse, criminalizing love jihad scenarios absent in IPC. And the punishments shift towards reform, that is, a community service debuts as a penalty for 6 petty offences. For example, the defamation under section 356, and promoting rehabilitation over incarnation. Fines increased to reflect inflation, and mandatory minimums applied to 23 offences for deterrence. And the murder ground expands, that is section 101 versus IPC 300, it including mob lynching based on caste or race, addressing 2015 to 2013 spikes in such incidents. And yet, this enhancements like life imprisonment without remission for gang rape of minors, that is section 70 close to, raise proportionality concerns potentially exacerbating prison overcrowding, that is around 135% capacity in 2024. Overall, this BNS modernizes substantive law, but its 80% retention of IPC language risks perpetuating ambiguities as seen in early 2025 challenges to section 152's vagueness. And regarding the procedural reforms, that brings the Bharatiya Nagarik Suraksha Sanhita versus Code of Criminal Procedure. This BNSS with 531 sections add 44 provisions and 39 subsections, emphasizing timelines for speedy justice, a perennial CRPC flow where trials averaged 5 to 10 years. So the judgments made follow within 45 trial completion, that is section 392 versus, and charges within 60 days of first hearing, section 251. And 0 FIR, section 173, expanding the provision of section 154 of CRPC, and EFIRs enable pan-India registration, reducing jurisdictional barriers. With regard to the victim rights advance, section 193 mandates updates every 90 days, and section 398 allows direct appeals against acquittals and empowering survivors. With regard to the technology integration, a mandatory videography of searches or seizures, as per section 185, the forensic mandates for 7+ year offences, section 176, and audio video trials, section 530, aim to tampering. And the trials in absentia, section 356, address fugitive issues, though critics fear it erodes fair trial rights under Article 21. And with regard to the expansion of the police powers, the custody extends to 90 days total, within 15 days any time in 40 to 60 days, raising torture risk despite safeguards. And the medical examinations for rape victims within 7 days enhance sensitivity. So comparatively, the BNSS humanizes procedures, that is, for example, replacing inquiry with preliminary inquiry, but timelines strain under resource courts. And by October 2025, the pilot implementations in Delhi showed 20% of faster charge framing, yet 30% of forensic non-compliance due to lab shortages. When coming to the evidentiary reforms, that means the BSA versus the Indian Evidence Act, this BSA updates the Indian Evidence Act for the digital era, equating the electronic records to primary evidence, that is section 57 versus Indian Evidence Act section 635B secondary status, and facilitating admissibility of emails, CCTV, and blockchain data. And it adds one section, amends 23 and repeals 5, expanding confessions, that is section 23, including audio video versus Indian Evidence Act section 27's oral only. And the secondary evidence now includes oral accounts, that is section 61, it aiding illiterate witnesses. So with regard to the forensics bolster credibility, the certificates under section 63 verifies digital authenticity, curbing fabrication seen in cases like fabrications which can be seen in so many cases, yet without robust data protection, vulnerabilities persist. So the BSC's victim-friendly tilt allows prior sexual history exclusion, which reducing traumas. However, expert opinions remain hearsay prone, which mirroring Indian Evidence Act laws.
Ma'am, I'm sorry to interrupt you, but if you could please conclude, ma'am. We are running short on time, ma'am.
Yeah, sure. Yeah.
Thank you. Thank you.
Sure. So, as a conclusion, so I'm just want to say about the positive impacts. So there are the positive impacts are it empowers victims and enhances transparency, and it ensures community service and gender neutral laws promote inclusivity, and EFIRs increase reporting access to justice is just a positive sign, and it boosts conviction, which rates in cyber and organized crimes, and it also supports economic efficiency through faster dispute resolution. So these are the criticisms and challenges regarding the new reforms. And finally, this is the implementation status as of November 2025. And as a conclusion, I would like to say that this India's new criminal laws herald a paradigm shift, embedding technology, victim rights, and efficiency into decolonized framework. Yet with substantive retentions, procedural expansions risking abuse, and evidentiary advances undermined by infrastructure deficits, they risk enforcing old inequities. So the true transformation demands policy reforms, judicial investments, and vigilant oversight. So as Chief Justice Chandrachud noted, impact hinges on capacity building. By 2030, periodic audits could ensure Nyaya prevails over Dhand, fulfilling the constitutional vision of justice for all. So that's all about the presentation. Thank you.
Thank you so much, ma'am. And all remaining participants, I'd like to sincerely request to please adhere to the time, and we are shortening to 5 to 6 per speaker. So please strictly adhere to it. And next, I'd like to call S. Kumoda for the presentation. Please.
Yes. Sir, I would like to
Will you be
share.
presenting? Sure. I have
Yes,
made you a presenter.
Yes, sir. Yes, sir. Yes, sir. Yes, this is Kumuda. I'm a research scholar from Wales Institute of Medical and Technical Sciences, and my topic, which I have chosen, is victim-centric justice and prisoner rehabilitation, analyzing the healthcare provisions for female inmates as a restorative mechanism. Yes. Our Indian criminal jurisdiction, there is a shift from retributive to rehabilitation, and also the victim empowerment. And under this new act, that is Bharatiya Nagarik Surakshik Sangita BNSS 2023, it focuses on this victim rights, and also as per the record of BCRB, that is National Crime Bureau record of Bureau, there are 4 to 5% of the inmates are actually women prisoners. And the research problem is that, can the healthcare for female inmates serves as both rehabilitative and victim protection? And as part of my research work, I have made some research objectives, that is analyzing the link between the victim-centric justice and rehabilitation, and evaluating healthcare standards for female inmates, and also to examine victim offenders nexus in women's criminality, and also recommending integrated policy frameworks. I have used doctrinal and analytical approaches in this research thing. And yes, regarding this linking victim protection and rehabilitation, the main goal of this thing is to prevent the crime, and there are 3 mechanisms I have included in my research paper. First one is recidivism reduction, that is the recidivism can be reduced by the way of trauma and addiction treatment, and also intergenerational prevention, that is support for mothers there are, and also healing victim offenders. Most female victim offenders are like they are like they've been abused, or they are being subjected to violences. And the next thing I have
I have stated some legal framework. That is, we have Article 21, which is right to life and personal liberty, and which is indirectly, it is also talking about the right to health also, and it indirectly includes the female like prisoners also, either male or female or transgender. It indirectly, it is talking, it is giving space for the, it is giving right to health right also. And under Article 14, it is equality before law, and Article 15, there should not be any discrimination. And also in directive principles of state policy, Article 31, it is talking about 39, it is talking about the, it is the state duty to make legislation, to legislate legislations regarding this health care. And some of the judicial provisions, pronouncements are, is this Sunil Batra versus Delhi administration, decided in the year 1978, where this fundamental rights is also for the prisoners. And though they are their liberty, like though not their liberty is only curtailed, not the fundamental rights. And with regard to this Sheila Basi, decided in the year 1983, it is talking about inhuman treatment of women prisoners. And this Delhi Domestic Working Women Forum, they are talking about the victim rehabilitation duty. And in the year 2016, there was a public interest litigation filed for the inhuman conditions of the prisoners, where they ordered prisoner health care reforms. And recently 2021, in the Sukanya Shanta case, where it is talking about, where it is giving importance to menstrual hygienic rights. And these are all the some of the challenges they face. That there is overlapping, that is 70 to 80% of the in capacity is that is 70 to 80% of the inmates, that is female inmates, are either from abuse or violence. And they also have some health issues like reproductive disorders and mental illness, and inadequate in menstrual hygiene. And these are all the challenges they face, that is, as a female incarceration, as a female inmates, as a female prisoners, they face these types of challenges. And in conclusion, what I'm trying to say is that by my research paper, that is, the victim centric justice and prisoner health care are mutually reinforcing. And some of the recommendations I have given, like I am recommending law system, that is central law system, for the uniform prison health care standard, where this prison administration falls in the schedule 7 of list 2, where the state government has got authority, state government has got power to make laws regarding this prison administration. In that cases, there is no uniformity in the uniformity in the prison health care. And also integrate BNSS with the prison reform policies, and also adopt trauma informed and general responsive care. And there should be continuity in treating the post release offenders. And also some established joint funding for victim support and rehabilitation. As a conclusion, I would like to say that this justice system that heals offender, and also it protects the victims, and also it upholds human dignity. Thank you, sir.
Thank you, ma'am. Nice presentation and keeping it short. Next, I'd like to invite Professor Chandrakanti and Mahintisha B for their presentation.
May I audible, sir? Hello, may I audible, sir?
Sir, you are audible, sir.
Yes, sir. Good afternoon, one and all present here. Myself, Mahantesh. I am going to present on the topic of a critical analysis on the effect of procedural deadlines under the special criminal enactments in India. I have a PPT, but due to a shortage of time, I'm not going to share that PPT. I will finish it within 5 minutes. I will
Thank you so
understand
much, sir. Thank you.
the
Thank you so much, sir. Thank you.
organizers' efforts. Okay.
Thank you, sir.
Going by introductions, that in India, the justice must be fair and timely. As we followed the major tagline from the past year, the justice delayed is justice denied. And one more thing is delay undermine the public confidence and the constitution value. As we adopted Article 21 of the Constitution as a heart of the Constitution, that Article 21 gives the right to life and the liberty. In that article, we interpreting that including the speedy trial as a fundamental rights. This was evolved in the case of Husainira Khatun versus State of Bihar in 1979. In that, majorly, when we are going to the criminal procedure or the trial procedure, it is the sole responsibility of the state. It is the duty of the state to ensure the timely, fair, and effective criminal systems. When it comes to the meaning and purpose of the procedural deadlines, means the procedural deadlines means a statutory time limits for investigation, trial, or inquiry. When it comes to the procedure, we only focusing on the trial aspect, but if you take on a criminal trial or if you take on a criminal any cases, that not only stick onto the trial, it will start from the investigation, it will start from the inquiry, and it will end with the trial. Like this way, the purpose of these procedural deadlines to prevent unreasonable delays, protecting the liberty of the accused, as well as guaranteeing the prompt justice to the victim, and moreover, preserving the public trust in the legal systems. We are majorly focusing on the societal aspect. See, as we studied in the jurisprudence also, we more focusing on the social perspectives and the social psychological angle. And moreover, it's representing the constitutional fairness under Article 21. As I told, we consider as a speedy trial is a fundamental rights. Hence, we need to uphold the constitutional validity. The procedure deadlines under the special criminal statutes. As I told, we have categorized into procedure laws and substantive law. Substantive law, it's only determines our rights. The procedural law, it's a pathway to take in our substantive rights. As we created a one set of criminal laws, like to conduct the all trial, as we know as a CRPC, now it's a change to BNSS. Apart from these statutes, we enacted the many other special statutes like POCSO Act, SC/ST Act, Juvenile Justice Act, Prevention of Corruption Act, UAP Act. These all act is a special enactments for they have their own substantive laws and as well as the procedure laws. In these statutes, they are giving the restrictions. For example, in a POCSO under Section 35, they given time limits to investigation within 2 months, and trial should be concluding the 1 year. If you take an SC/ST rules, that says that investigation should be completed in 60 days, sorry. And if you take in Juvenile Justice Act, that inquiry should be concluded within 4 months. If you take a Prevention of Corruption Act, the trial should be end in 2 years. Likewise, if you take an UAP Act, NDPS Act, in NDPS Act, they given up to 1 year with the court permissions, and Domestic Violence Act in 2005, it's a procedure deadlines for hearing within 3 days, first hearing within 3 days, and disposal within 60 days. See, these are the special statutes. They given a own procedural deadlines. For these, there are many judicial interpretations. Like as I told, Husainira Khatun in 1979, it's a delay, it's a violation of Article 21. And another thing, Air Antulle in 1992, it says that extended right to all the stage of investigations to appeal. There are classification of the 3 factors in that: the length of delay, the reason for the delay, and the conduct of the investigation, and the cause of prejudice. These are all the elements should be justified by the judicial aspects. And another thing is the speedy trial, it's a constitutional mandate and not an administrative ideal, because we cannot blame all time to the executive for not completion of investigation within the times. The court have the writ of mandamus. Through the mandamus, they can enforce to the executive to achieve the constitutional mandates. Otherwise, and other provisions like enforcement through the default bail, section 167 2 CRPC. This provision says that whenever the special statutes or the ordinary statutes fails to complete the investigations 6 days or within 90 days, the default bail should be granted. It's a matter of rights. This has interpreted in several statutes as well as in several precedents. The major constraint here is whatever I stated in the special statutes and the special provision, that comes to that whether that is a mandatory or the directory. See, some of the interpretations in a case in Madan Lal Srivatsav in 1957, they stated that the legislative intention plus the consequence of the breach. See, the criminal cases is not each similar cases. They have the independent nature and they have independent different from the case to case basis. While that in section 167 2 CRPC, the court interpreting that it's a mandatory provision, and in certain like POCSO, SCST rules, JJ Act, these are all provision is merely directory. It's not a mandatory. The delay is excusable if justifiable. Means the investigation, whatever all told in the statutory limits, it can't be possible due to the many reasons. Hence, the court have the different opinions that whatever the stated in the special statutes, it's not a mandatory, it's a mere directory. Hence, I'm moving on to the challenges. There are many challenges has been facing by the Indian judiciary as well as the administrative part. The systematic institutional delays. For example, in India, we have more than 4.3 crores of pending cases, 30% judicial vacancies. We are still facing that. And majorly the poor infrastructure facilities and inadequate special courts. As I told, whatever are special statutes, they preferred more special courts for adjudication. But if you take in a practical reality, there is no appointment of special courts till now. And investigation backlogs. The police under resources, forensic and staff gappings. POCSO and SCST Act investigations often extend the statutory limits. For example, certain grievous offenses like a POCSO, like an DV Act, like an NTPS Act, even if you take in a UAPA, these are all the crimes need a special investigation team and a special forensic time. We have a lack of on that. That is also major challenges. And cultural technical issues. Cultural adjournments in Malamat Committee 2023 stated that the weak awareness, limited digital integrations. See, we have adopted like an digital India concept, but we are not fully adopted that digitalness to the investigation or the trial. My suggestion is that we need to adopt a more technological advancement into trial as well as investigation. We can achieve, as many judiciaries also adopting the e-court systems and the e-technical systems. Likewise, that if investigation team is also adopting the digital help, it can be useful to adjudicating and useful to achieve the procedural deadlines. By concluding saying this, the procedural deadlines, expressions of Article 21's promises of the speedy justice, the succeeded depends upon the institutional disciplines and judicial accountability and technological modernization and trainings and resources strengthening. By concluding this, I have this opinion that we need to adopt the more technological aspects as well as we need to convert deadlines from symbolic provisions to enforceable rights. I think if panel have any clarifications or anything, I may ready to answer to that.
Yeah, we will conclude at the last. We'll take up all the presentations. Thank you.
Sure, sir. Thank you. Thank you for this opportunity. Thank you.
Thank you. Thank you. Next, I'd like to invite.
Hello.
Yes, Mr.
Sir, is it okay if I just give my concluding speech now or at the end?
If you could just conclude in a minute or two.
Yeah, I can conclude it in a minute.
Yes, yes, please, please, please.
I would like to conclude by saying that the Bharatiya Nagrik Suraksha Sanhita 2023 stands as a landmark reform that redefines India's criminal justice system. It is built on four strong pillars: timeliness, transparency, digitalization, and victim participation. It ensures that justice is delivered swiftly, fairly, and with accountability. Through digital justice, citizens can now file FIRs online, receive e-summons, and attend virtual hearings, making justice more accessible, though data privacy must be carefully protected. The emphasis on forensic investigation brings science into the heart of policing, reducing reliance on confessions and improving accuracy, though it also calls for better labs and expert training. At the same time, every reform must remain within the bounds of the Constitution, respecting the equality under Article 14, freedoms under Article 19, and due processes under Article 21. The Maneka Gandhi judgment reminds us that speed can never come at the cost of fairness. Of course, the biggest challenge lies in the implementation, bridging digital divides, upgrading infrastructure, and ensuring training for officials. With proper effort and vigilance, however, this reform can transform justice from an aspiration into a lived reality. In essence, BNSS marks India's long-awaited shift from colonial control to constitutional justice, from a system designed to rule people to one designed to serve them. It is a step towards modern, humane, and inclusive legal system, one that truly upholds the ideal of justice by the people, for the people, and in the service of the Constitution. Thank you.
Thank you very much. So all the remaining participants, I request you to please conclude it in 5 minutes. Next, I'd like to invite Mr. Nirupam Sutradhar. Mr. Nirupam Sutradhar, if you could please start with the presentation. Okay, moving forward. I'd like to invite Mr. Vinay Atri and
Hello.
Dr. Professor Manish Yadav.
Hello.
Hello.
I'm Nirupam. Sorry, I was having some issue with the mic.
No worries, no worries, no worries.
Am I audible?
Yes, you're. Yes, you're.
Can I just present a PPT? I'll be quick.
I made you a presenter, but please try and conclude it in quickly.
Yeah, sure. Is the PPT visible?
Not as of yet. Yes, it is now. We can see it.
Okay, good afternoon, everyone. I'll be very quick since we're in a time crunch. So, my topic is basically a critical assessment of Bharatiya Nyaya Sanhita, balancing the decolonization approach with the reformative punishment. The promise of decolonization of IPC was profound. It replaced the old law with a clear intent to modernize and a systematic change for a citizen-centric approach. However, some of these changes are yet to be seen, since 80% of the provisions of BNS are either direct copy or with minor rephrasing of old IPC. The fundamental legal architecture has largely been same. The controversial marital rape exception still exist. The core offense of rape still remains gendered, which has failed with the modern times. And we continue to use archaic language such as outraging the modesty of a woman, which is still an idea which was taken from the Victorian morality. However, if we take another look, we have some positive changes. That is a reformative turn towards community service. Community service is a way of moving away from punishment to a more restorative approach. Though it is for 6 minor offenses, that is theft under 5,000 rupees for first-time offender, defamation, misconduct in public, suicide attempts, etc. It is a welcome change. It has brought a very new idea in Indian jurisprudence. However, at the same time, we have a punitive counter narrative for crime against the state, which has, though changed from the colonial period, still has the stench of the colonialism, still has the stench of the old laws. This has codified organized crime, terrorist act with broad definition and severe penalties, ranging from 5 years to life imprisonment to death penalties. Furthermore, while the old Sedition Act is omitted, it is effectively replaced by Section 152 of BNS, that is the Act Endangering the Sovereignty, which uses vague language, undefined terms such as subversive activities, which can be anything, ultimately perpetuated a colonial logic of using this penal law as an instrument of state security. It can have a very chilling effect on the free expression and speech in India. These are some of the most outrageous acts. Though accepted by the most, it can also be used as a political tool by the party in power, as we have seen in many times under many administrations. These have a dangerous effect on the civil liberties. This brought basically a bifurcated justice system, a dual-tier jurisprudence, where tier 1 applies to petty non-violent offenses, whereas the tier 2 is harshly punitive and retributive approach, which is reserved for any act that challenges the state authority. These punitive measures clearly overshadowed the reformative elements, and the colonial logic still continues. However, if we take the critical assessment and the paradox of BNS, it embodies our reformative aspiration seen in the community service that coexist with overwhelmingly punitive counter-narrative and the failure to decolonize the social hierarchies. It mainly raises a big question. Are we genuinely seeing a structural reform, or is it merely a nationalist veneer on the old and unreformed colonial structure? If we go for the recommendation, for me, we need clear guidelines to define the nature of community service, standardize its implementation hours, establish supervisory mechanism which would monitor and manage the sentences. We must build this infrastructure, dedicated bodies that would manage these sentences efficiently and effectively. We should also expand the legislative scope for community service to include more non-violent offenses as a genuine alternative to short-term imprisonment. It would also help in reducing overcrowding of prison. In conclusion, Bharatiya Nyaya Sanhita promises ideas, but they are currently overshadowed by a state-centric punitive framework. Realizing its potential will require a dedicated effort to ensure these reforms evolve from a symbolic gesture into a meaningful instrument of justice and not just a nationalist approach to law. Thank you.
Thank you very much. Next, I'd like to request Mr. Vinay Athuri and Dr. Professor Manish Yadav to present.
Yes, sir. Namaskar, sir. Sir,
Sir, आपकी
so,
presentation
I'm
रहेगी?
audible, sir. I'm audible.
Yes, you are, sir. Yes, you are.
Sir, there is difficulty in uploading the presentation. I'm trying to brief in.
No worries, sir. We can go with this one.
Okay, sir. Good afternoon to all the respected members and my dear colleagues. I'm going to present the topic, the plight of under trial prisoners in India, which is now become a human rights crisis, presumed innocent for the prisoners treated as guilty in most of the cases right now. The under trial paradox in India, we all know that innocent until proven guilty in law. However, thousands of individuals are jailed for years before their trial even concludes. They are deprived of liberty and dignity, not as punishment, but while waiting for justice. Basically, sir, who is under trial prisoner, sir? Who are we talking about right now? An under trial is a person in jail during the investigation or trial of their case. They have not been convicted of the crime. They are legally innocent, sir. But due to the lack of our system loopholes, they are still suffering for their justice. And after so many years, they released on as innocent, not proven guilty, but they placed in jail. So there are constitutional promise too. Article 21, which provides right to life and liberty, includes fair and speedy trial in Husainara case, famous case of Supreme Court. Article 22, protection against arbitrary arrest and detention. Article 39A, free legal aid, and for those who can afford it. There are landmark cases, sir. The Husainara Khatun versus State of Bihar 1979, which I'm just talking about. The Supreme Court declared that a speedy trial is a fundamental right. It affirmed that detention for long periods without a trial is a violation of Article 21. So what is the main difference and what is the reality check? I mean, on paper, there is a law, presumed innocent to everyone before proven guilty, right to bail, right to speedy trial, right to legal aid. However, sir, in practice, treated as guilty first, as they detained in the jail. Bail is unaffordable for the very poor person because their amount is so high. Endless delays. Legal aid is inadequate. What does this happen, sir? The core failure of the system is the bail trap. Bail is a right, but courts set high financial sureties, bonds. That the result, poor cannot afford to pay, the remain in jail only because they are poor, and the wealthy, even for serious offenses, can often pay and get released. So, sir, there are pre-trial detention, failures, sir, system collapse, or sir, prison conditions, most extreme crowding, bad sanitization, healthcare, and and we can also compare it in an international way also. The feature maximum detention time, India, there is no clarity, sir, for time. Even they are using it as per their whims and fancies according to the convict, sorry. And the human cost more than just a data, sir. This is not just legal problem, loss of job and livelihood of the family, sir. Family breakdown and social stigma. Several mental and physical health issues, sir. It is a systematic violation of human rights, sir. The way forward in this, a shift in mindset, sir, from punitive control to a right-based framework. Prioritize liberty, sir. make bail the rule, not the exception. Speedy trials, sir. Implement strictly within timelines, sir. And a close watch also required by some competent authority. Fund legal aid, sir. Accountability. Create a mechanism to hold the system accountable for delays and wrongful detention, sir. So I want to conclude by saying this. The status of the inmates of under trial in India remains a moral scandal, sir, of the criminal justice system in this country. It identifies the paradox of the constitutional ideals and day-to-day governance. Institutions do not maintain their right, and that is why underdetermined criminals end up being imprisoned, sir. Sir, in other way, I can say that, sir, law is nowadays is a abstract, sir, only. Abstract only, sir. There is no way to implement machinery, sir, within stipulated time, sir, and no one is going to watch. In the end, sir, I would like to say that what determines a democracy is not the extent to which the guilty are punished, but the way that the innocent awaiting trial are treated, sir. Justice in India will never be complete until under trials are assured liberty, dignity, and a fair trial. Thank you so much, sir.
Thank you so much for this nice presentation. Next, I'd like to invite Ms. Rashmika Srivastava for presentation. Ms. Rashmika Srivastava.
Am I audible, sir?
Yes, you are.
Good afternoon, sir. Good afternoon, everyone. My name is Rashmika Srivastava, and I'm third semester student from Professor Rajendra Singh Gachibowli University, Prayagraj. Today, I'm presenting my research on false promise of marriage and concept of consent. This topic is extremely relevant because these cases sits at a difficult interaction of bodily autonomy, trust, intention, and criminal liability. Under Indian law, consent is not just about physical willingness. It must be voluntary, conscious, and informed. Section 375 IPC defines rapes, and Section 90 IPC makes it clear that consent obtained through misconception of fact and deception is not a real consent. So, when sexual intercourse happens only because a woman believes a promise that marriage will happen, the intention of man becomes crucial. The court have consistently held that not every breakup or failure of marriage becomes rape. The test is, was the promise false from the very beginning? If the man had no intention or to marry and use that promise only to secure sexual access, then consent is said to be vitiated. But if he genuinely intended marriage initially and the relationship failed later due to family issues, incompatibility, or change of circumstances, it is not a criminal offense. So judicial reasoning evolved from cautious early reasoning like rulings like cases like Uday versus State of Karnataka 2003 to clearer standards by in the case of the proposed Suryaban Pawar 2019, where the Supreme Court finally drew a strong distinction between a false promise of marriage and a mere breach of promise. Modern cases like Mahesh Tamukhare and Prashant continued reinforcement this intent-based approaches. Section currently in our new criminal laws also inserted a law section 69 in BNS 2023 also which supports false purpose of marriage. That says promise based on manipulation or consent is not directly consent. So concluding, the current legal position protects women from deceitful exploitation under the guise of marriage while preventing other criminalization of normal failed relationship. It ensures that consent is respected and fully informed and voluntary discussion, not something obtained through lies and manipulation. Thank you.
Thank you very much. Now I'd like to invite and Ms. Sharmi Podar to do with their presentation. Ms. Dibanjali and Ms. Sharmi Podar.
Yes. Good afternoon, everyone. Am I audible?
Sure. Yes, you're audible.
So, I'm Navjit, my co-author. We are presenting our paper.
Do you have a PPT?
So we did a PPT for this topic, but since we are keeping our presentation brief, I'll go the key points.
It's all right. Please carry on. Essay. Yeah.
So, on protection highlights the greatest justice system and the urgent need to ensure that while giving testimony, witnesses the and use of justice. Statements help courts uncover the truth and determine the outcome of death in India. Many witnesses face information and harassment that define honestly. This not only the delivery of justice in the legal system. So witnesses include all procedural and witnesses from home. This may involve relocation, concealment, police or the emotional objective is to ensure that witnesses can testify freely, thereby upholding the principle. Globally, the concept of witness protection gained importance during the 20th counter organized crime and terrorism. In India, the need for witness protection became evident after several high-profile cases where witnesses turned hostile under pressure. From the Corporate Law Witness Protection Act 2018, India's legal framework has gradually evolved to ensure witness safety and judicial integrity. The idea draws strength from Article 21, which guarantees the right and personal liberty, and Article 4 to ensure equality provisions like Section 50 of the Indian Penal Code deals with criminal intent, while the Criminal Procedure Code to conduct in camera trial duty proceeding. In 2018, approved by the Honorable Supreme Court to provide identity and security to witness facing threat. So to conclude my part, but also a moral and constitutional obligation of the state. India has taken commendable steps. Witness Protection Act is essential to ensure consistent implementations across all states. This is the voice of truth, and only when witness the job and justice truly also Ms. Shurmi Kotavi.
Good morning to all present. I am Shurmi Purva, co-author of this paper, and I would like to highlight some of the core findings and recommendations from our study. Our research further examines the challenges that continue to hinder the effective implementation of witness protection in India. Although the Witness Protection Scheme 2018 was a landmark initiative approved by the Supreme Court, its execution has been inconsistent across the state because it has not yet been enacted as a law. Many still face issues such as lack of funds, inadequate training of officers, and limited awareness about the rights and support available to the witness. This has created a significant gap between policy and practice. Many witnesses, especially in sensitive criminal cases, still face pressure to react their statements or avoid testifying altogether. Such incidents directly affect conviction rates and erode public trust in the justice delivery system. Our paper also highlights that witness protection must extend beyond physical safety. It should address the psychological, financial, and social aspect of protection. Witnesses often face trauma, loss of livelihood, or social ostracism after appearing in the court. Therefore, counseling, relocation support, and financial assistance should be an integral part of any comprehensive protection framework. We have proposed several reforms to strengthen the system, the establishment of a National Witness Protection Authority to coordinate implementations, ensure proper funding, and monitor compliance, greater use of technologies such as video testimony to minimize exposure, and most importantly, the enactment of a comprehensive witness protection law to provide statutory backing to the existing schemes. To conclude, witness protection is the foundation of a fair and credible justice system. A witness who speaks without fear strengthens not just a case but the entire rule of law. Protecting witness means protecting the truth, and protecting truth means upholding justice itself. Thank you very much.
Thank you very much for a nice presentation. Now I'd like to request and invite Dr. Namika Singh to present. Dr. Namika Singh. Okay, moving forward. Now I'd like to request and invite Mr. Vignesh Kumar and Dr. K. Ganesan to present their. Yes, sir.
Good afternoon, sir. Good afternoon, sir. Am I audible?
Yes, sir.
Yes, sir. Today, my name is Vignesh Kumar. I'm going to present a topic on rights of arrested persons under New Criminal Justice Reform 2023. Since we all know that new criminal reforms has been bring by the 2023 replaced the Criminal Procedure Code and Indian Penal Code, says that how the punishment should be derived and the criminal justice administration to be followed in this current era. And there are various case laws. What is arrest? Arrest is a person to be arrested by the police to make an investigation and to provide justice. And in this part of time, there are various problems arising by day and day. So the custodial violence are emerging, and the custodial violence are increasing day by day. So the case law, the landmark judgment has been derived in the 1997 called D.K. Basu versus State of West Bengal, which gives various guidelines to make the arrest procedures and how the arrest should be done, who are the persons to be informed, and how the arrest procedure to be done, investigation procedure to be done before the court of law. From various cases, Joginder Kumar was a state of UP, and how the constitution is protecting the arrested person's liberty. Article 21, right to life, and he has a right to get a free legal aid. He has a right to get a legal consultancy from the lawyer. He has a right to meet the lawyer, and he has a right to get the bail. Since we are following jail is a rule, bail is an exemption. So arrested persons are also a human dignity, has a citizenship. So though they are arrested person, we cannot deny their human rights. So the human rights protects the arrested person from the various forms. Under BNSS, the various law sections provisions has been emerged in the name of arrest procedures, rights, powers of arrest, and who has the power to arrest, and the duties of the officers, and section 47, right to bail, since arrested person also has a right to get a bail. So privilege, section 57 says that the arrested person has a right to make a privilege before the court of law, before the judicial magistrate. So since these are the major effect has been brought by the new criminal justice reform, but there is no more changes, but the problems are arising day by day. This has to be implemented in the new criminal justice, and the new guidelines to be followed. Since 1997 guideline has been after 2 decades has been happened, so new guidelines to be performed by the criminal justice administration. And the conclusion is the landmark judgment, and judgment says the human rights of the arrested person to be protected, since Article 14, 21, 22, 22 plays a vital role in the protection of detained person, arrested person. And thank you, ma'am. Thank you, sir.
Thank you so much, sir. Next, I'd like to invite Ms. Swati Chauhan and Mr. Mandir Singh.
Good afternoon, everyone. My name is Swati Chauhan, and I will be presenting on the topic Ensuring Justice Through Protection, a study of witness protection laws in India. Jeremy Bentham has famously stated that witnesses are the ears and eyes of justice. This quote emphasizes the crucial role played by the witnesses in the justice delivery system. It is the statement of the witness which is the determining factor in either acquitting or convicting the accused. It forms the basic foundation of fair adjudication in the justice delivery system. However, in India, witnesses often face threats, coercion, intimidation, and they turn hostile. Particularly women witnesses, especially in sexual offences cases, and witnesses belonging to marginalized communities often face more risk in this respect. The 198th report of the Law Commission of India in 2006 highlighted the urgent need for statutory measures to protect witnesses and proposed creating witness protection program. In Zahira Habibullah Sheikh versus State of Gujarat, the Honorable Supreme Court stated that it is high time to address numerous experiences faced by courts on account of frequent turning of witnesses as hostile, either due to threats, coercion, or monetary consideration. As a protector of its citizens, the state has to ensure that during a trial in court, the witnesses could safely depose against the accused. Article 14, 21, and 39A of the Constitution of India may be considered as foundation stones for witness protection. Section 55 of Bharatiya Sakshi Adhiniyam emphasizes on oral evidence given by witnesses in different circumstances and its relevance during trial. Section 137 of BSA further provides that witnesses can be compelled to answer questions put to them. However, they may not be subjected to any criminal proceedings in this respect. Further, Section 153 imposes a restriction on the lawyers not to ask any question on any unreasonable ground. Moreover, Section 154 provides that court may forbid any questions which may be scandalous or indecent. Section 366 of Bharatiya Nagrik Suraksha Sanhita provides for public trial. However, there may be cases in which in-camera trial may be more appropriate, so that victim or the witnesses may depose freely without any threat. Section 398 of BNSS is very important to mention because it mandates all the state governments to notify and prepare a witness protection scheme. Further, Section 232 of BNS provides for punishment for threatening any person to give false evidences, and Section 72 prohibits the disclosure of identity and publication of names of victims and in certain crimes. Now, it's pertinent to mention the case of Mahendra Chawla versus Union of India. In this landmark judgment of Honorable Supreme Court in 2018, this case led to the implementation of the Witness Protection Scheme 2018 in India. The case involved witnesses testifying against a high-profile accused, and the witnesses were subjected to threats and violence. The court directed the government to protect witnesses and gave the Witness Protection Scheme the force of law under Article 141 and 142 until formal legislation was enacted. The Witness Protection Scheme 2018 divides witnesses into three categories. Category A involves most severe threats that extend to the life of the witness and their family members. Category B involves threats that may affect the safety, reputation, or property of the witness or their family members. Category C involves moderate threats Now, the threat analysis report is prepared by the police, and the particular protective measures are chosen by the competent authority. The protective measures may involve relocating to a safe home and changing one's identity and providing personal security, etc. This scheme aims to providing protection at both immediate and long-term levels, as it may provide protection even after the trial is over. Now, however, this scheme has certain limitations, as not all the states have implemented this scheme uniformly, and there.
Swati, if you could please conclude
yes,
in just
okay.
a minute or two. Thank you.
And there is limited budgets and lack of trained personnel. The Witness Protection Bill was presented in 2023. However, it has not been passed yet by the legislature. To conclude, I would like to suggest some reforms. That there needs to be establishment of specialized witness protection units at national, district, and state level, and training for police and prosecutors and judges. And there needs to be integration with social support like housing, counseling, and livelihood assistance for the affected witnesses. And there needs to be a balance between protection of the witnesses and fair trial rights. Thank you.
So much for a very nice presentation. Next, I'd like to invite Mr. Arindam De and Dilkar Sama to present.
Good afternoon, sir. Am I audible?
Yes, you are.
Very good afternoon to everyone. I'm Arindam De. I'm going to discuss about a topic titled The New Criminal Justice Architecture, Speedy Justice and Fair Trial. So, this topic has been researched by me, Arindam De, and my co-author, Ms. Dilkar Sama. So, starting with the topic, speedy justice and fair trial. They are two of the most fundamental principles of our criminal justice system. Speedy justice is basically means that the individual, specifically the accused, they must be tried without any undue delay. Based upon a principle, is justice delayed, is justice denied, justice withheld, is justice withdrawn, and justice should not only be done, but it also appeared to be done. On the other hand, the concept of fair trial means accused, he must be treated justly and in an impartial manner. In our constitution, Article 20, 21, and 22, it deals with this two main principles. In the case of Husainara Khatun versus State of Bihar, the Honorable Supreme Court, it expressly stated that the prisoners has right to speedy justice and fair trial. In the newly passed criminal laws, specifically the Bharatiya Nagarik Suraksha Samhita 2023, it aims to reduce delays and modernize court procedural system. It also based upon a principle of justice delayed is justice denied. But we have to look upon that whether the excessive fast judgments and trials, whether it leads to an error or wrongful conviction or not. We must look into that also. So directly going to the key provisions of Bharatiya Nagarik Suraksha Samhita, as it specifically deals with the procedural aspect, I would directly go into that. The first issue that it deals with is the investigation. We know the investigation is one of the primal issues that need to be addressed, because we saw the investigation has been dragged out for a long period of time. That issue has been addressed by BNS section 193. It stated that if a punishment for which the imprisonment is less than 7 years, the investigation must be completed within 90 days. And if it is 7 years or above, it must be completed within 180 days. So a specific strict timeline has been set. However, it may be extended by Superintendent of Police if in complex cases. Framing of the charges is also one of the important issues that has been addressed by BNSS. We have seen that framing of the charges has been completely hampered many times due to adjournment motions and rescheduling issues. In section 230 of BNSS, strictly informed the court to frame the charges within 60 days from the date of its first hearing specifically. Completion of trial is another important issue that has been addressed in our in the new BNSS. Specifically, section 356 of the section stated the court must complete the trial within 2 years from the filing. However, if the additional time is required, the court must state the reason in writing. So that issue has been addressed. The BNS it's also it incorporated various technological measures such as video conferencing trial. So section 532 of BNS, it uses video conferencing methods in all stages of investigation, inquiry, and trial, and it also provided certain procedural safeguards as well. Electronic communication, warrant, and summon. It also a new addition to the BNSS. Section 69 of BNSS empowers the court to issue summon, warrant, and other legal notices through an electronic means, completely bypassing the traditional postal method, which causes many delays. Digital recording of evidence is another important addition into BNSS. Section 532 subsection 2 specifically stated that if the witness is vulnerable, then his statement must be recorded through an audio-visual means. The code also streamlines the bail proceeding. Section 479 stated that the court must decide the bail proceeding within 7 days from its filing. So that is also an important issue that has been addressed by BNSS. And the role of victim participation during this bail proceeding is also an important issue. In serious cases, the court also empowers the right to the victim, the right to be heard in serious offences when the bail proceeding is going on. So the victim participation has also been addressed. And another important issue, a major issue that has been faced by our Indian criminal system is the absconding of accused. We all know about Nirav Modi case, Vijay Mallya absconding case. So when these kind of accused offenders absconded, in such case the trial stuck. But in this in BNSS section 356 subsection 6, it empowers the court to continue with the trial even after the accused or the offender has been absconded. The court can proceed with the trial after recording of the reasons. Plea bargaining and summary trials, another important issue that has been addressed, which empowers the court to directly go to summary trial in cases where the crime for which the imprisonment is up to 3 years. In such cases, court can completely bypass the full procedural delays to avoid any kind of delay. So these are the statutory changes that have been made in BNSS. However, we have to look upon that there are some major issues that not being addressed.
If you could please conclude. We are running short of time.
Yes, sir. Yes.
Yeah, we're running out of time, please. Thank you.
Yes, sir. So, in the end, I would like to conclude that the BNSS, it provides various structural changes and statutory changes, but there are some significant issues such as judicial vacancies. India doesn't have enough judges, and even in the existing judges, 30% of the seats are vacated. That need to be addressed. Secondly, the police investigation quality. Just merely giving the timeline, it doesn't help. If the quality has been of investigation is hampered, shortage of staff, poor training, issues need to be addressed. Digital divide. There are many district courts in India is still lacking the proper infrastructure such as video conferencing, high-speed internet, and trained professionals that need to be that not being given to them so that they cannot absorb the digital revolution, and lack of adequate funding that need to be addressed, because in today's time, national legal service authorities institutions, they are not being funded properly. So in the end, I would like to say that these kind of additions, putting the strict timelines in investigation and trials and absorbing technologies such as digital evidence, video conferencing, it raises a strong voice to our Indian legal system that it is going to modernize. However, its success depends upon its effective implementation and resolving the problems of judicial vacancies, weak investigation, and undue digital divides. If it has been done successfully, then Indian legal system would grow not only theoretically but also actually. By this, I would like to conclude my presentation. Thank you.
Thank you very much. Thank you to all for your presentations. Now we would like to move towards the end of this session. I'd like to invite the chairperson, sir, the honorable chairperson, sir, Dr. Santosh Kumar Sharma sir for his comments on this session.
Thank you. I think all presenters has tried their best to make the presentation. However, the detail we have with us, that is, they are including diverse field, but something which was expected, though to some extent that is successfully met, and some I think that in the time of present situation where we have lot of resources to research upon, we can have better like tools and measures to come up with the conclusion. Some of the topics obviously are very appreciable, though they require further research. With some of the moot points we can look into that, we find something that some of the adjectives used by some of the that presenters, like plight of and false promises, protection of witnesses, and we find that colonial era has been used time and again in some of the papers. So, as a law researcher, as a teacher, as a colleague, but we find that we should avoid the adjective in law. If we research something by a particular adjective, it means we have already decided. We cannot think beyond it. We have already made the judgment. So if we say plight, then obviously we will research from that point of view. As a researcher, we need to be neutral. We need to be very objective oriented, and we can be objective oriented only when we are neutral in research. If we are researching with the mindset, we research with the mindset that men are really the violator, women are really the sufferer, then we find only those quotations, those those provisions, and their readings accordingly. This is just my but if we look at some of the objectives which were set out or which were very much highlighted at the time of commencement of these three new laws, we as a citizen, and particularly being the law researcher, we have to think some of the basic points. Like I give you a few points and conclude that if you see the salient features of these three new criminal laws, what is the purpose of criminal law? That it will curtail the crimes in the society. I suppose that in modern time also there are four basic objectives which criminal law try to achieve. One, obviously, that is the reformative concern is the priority nowadays. We consider that that preventive approach is another one, and exemplary approach sometimes we find like in the acid attack and others, and this approach of like last 15 or 20 years that to inflict the death penalty in some of the offenses. And another one very natural ingredient essence which will remain forever, that is a feeling of the satiation and feeling of the vengeance. So these are the objectives. Any form of the provision have to be judged from these points of view. How successful we are that our earlier law and present law. I give you some of the facts that in BNS punishment has been increased in 33 sections, and fine has been increased in 83 sections. Moreover, a very glaring fact that mandatory minimum punishment introduced in 23 sections. It's not common concern. Some of you referred the Bentham. If you see the Benthamite principle, one of the prime or one of the premises on which he elaborated that minimum pain, maximum pleasure. That is why in the provision we find maximum, like a theft punishment up to 3 years. Meaning thereby if somebody has stolen like some edible, some slice of bread, some samosa or like, then that person does not deserve to be like imprisoned for. But on the principle of or essence of the theft, person might be convicted. So this is the concern. And moreover, in 13 offenses, death penalty has been inflicted or has been provided in BNS in comparison to in comparison to 8 in the previous law. So as a researcher, what inference we can draw? We have been failed in last since the commencement of the constitution. Prior to the, we can take this excuse कि चलो पहले अंग्रेजों की सरकार थी, but 75 years में we have failed even to make our society so realizable. We are demanding more and more stringent punishments. We are demanding more and more death penalty. Is it actually something what we have achieved? Rather, in new criminal laws, provisions should have it is our achievement when less provisions, death penalty are required in least of the provisions. So this is, as a researcher and others, if we look into these kinds of areas, it would be more fruitful. It would be a kind of the addition to the existing research or existing literature. But overall, I congratulate all the presenters on their successful presentation. I thank thank you for, and I thank co-chair and the moderator of this session for so nicely moderating this session. It is very hectic task to say somebody that please conclude. It's not easy, and sometimes. So thank you very much.
Thank you so much, sir, for these insightful comments. And as I'm sure that as legal professionals, law students, and research scholars, will move forward with these comments and work upon it. And now, moving forward, I'd like to invite the co-chairperson of this session, Dr. Kiran Singh, for a vote of thanks.
Once again, thank you, Deesh. Once again, a very good afternoon, everyone. Is my voice audible?
Yes.
Yes, ma'am, you are.
Okay. So as we come to the close of this intellectually enriching session on substantive criminal law reform, it is my privilege on behalf of the organizing committee to propose vote of thanks. First and foremost, my heartfelt gratitude goes to Dr. Santosh Kumar Sharma for his thought-provoking and insight address. Sir, your deep understanding of the nuances of criminal law, particularly the BNS Act, your clarity on the evolving legal framework, and your reflection on justice and reform have truly enriched today's session. Your emphasis on aligning substantive criminal law with constitutional values, fairness, and human dignity has given us much to think about. We are grateful for the clarity and depth you have brought to this session. I would also like to thank all the participants for their keen interest and active engagement throughout the session. Your presence and thoughtful attention have contributed immensely to making this session meaningful and impactful one. Sincere appreciation also goes to the organizing committee for their meticulous planning and coordination, which ensured the smooth conduction of this event. My sincere thanks goes to the technical and administrative team for their behind-screen effort, and also to the fact that at times it go unnoticed, but they are very much vital to the success of any academic program. So as we come to the conclusion of today's deliberation, today's session, let us remind us that reform in criminal law is not a one that involves legislative effort, but an ongoing intellectually and moral process, one that demands critical reflection, collaboration, and reformation, and commitment to justice, victim protection, and rehabilitation, which is the present requirement of the present system of law. So let us carry forward this idea and perspective of today, continuing the dialogue on how we can serve, how criminal justice system can serve as an instrument of fairness, equity, and human progress. Once again, I extend my thanks to Dr. Santosh Kumar Sharma sir for gracing us with his presence and to everyone who contributed to making this session a success one. Thank you to all.
Thank you, ma'am. So to all the participants, our next session will start from 2 a.m. From 2 p.m. Thank you very much for joining.
Am I audible? Good noon, everyone. I welcome you all back to the post-lunch session of our national seminar on criminal law and justice reform. The theme of this technical session is procedural criminal law reform. This session will focus on the procedural dimensions of India's new criminal legislation, the Bharatiya Nagrik Suraksha Sanhita, and related changes that aim to ensure speedy justice, accountability, and technological innovation in investigations. We are honored to have among us distinguished academicians to guide the deliberation of this session. First, Chairperson Dr. Preeti Rana, Assistant Professor, Faculty of Law, University of Delhi. Co-Chairperson Mr. Adarsh Pandey, Assistant Professor, School of Law, G.H. Raisoni Skill Tech University, and our moderator, Ms. Abhiruchi Lakras, Assistant Professor, School of Law, G.H. Raisoni University. I'll hand over the session to Abhiruchi ma'am.
Good afternoon, everyone. I hope I'm audible. I, Abhiruchi Lakras, Assistant Professor, G.H. Raisoni Skill Tech University, Nagpur, extend a warm welcome to all the dignitaries, participants, and presenters assembled here for the technical session 2 of the National Seminar on Criminal Law and Justice Reforms, organized by the School of Law, G.H. Raisoni Skill Tech University, Nagpur. We are privileged to have two eminent academicians to preside over this session. It gives me great honor to introduce our chairperson for this session, Dr. Preeti Rana, Assistant Professor, Faculty of Law, University of Delhi. Dr. Rana is an Assistant Professor at the Faculty of Law, University of Delhi. She completed her education at St. Stephen's College, University of Delhi, and London School of Economics and Political Science, United Kingdom. She holds a PhD in Law from the Faculty of Law, University of Delhi, with a specialization in the harassment of women in NRI marriages. With over a decade of experience in teaching and research, Dr. Rana has contributed extensively to the field of law. Her academic pursuits and publication focus primarily on women's rights and related socio-legal issues, and she has been an active speaker at various academic professional forums. It is also a pleasure to introduce the co-chairperson, Mr. Adarsh Pandey, Assistant Professor, School of Law, G.H. Raisoni Skill Tech University, Nagpur. Mr. Pandey is a young and dynamic academician whose research interests include criminal jurisprudence, constitutional law, and procedural justice. His participation adds value and institutional perspective to this session. Now, to formally commence the proceedings, may I invite our respected chairperson, Dr. Preeti Rana, to kindly deliver the opening address and share her reflections on the theme of procedural criminal law reforms. Ma'am, please.
Namaskar. Good afternoon to one and all present here. Am I audible? Am I audible?
Yes, ma'am, you are audible.
Okay, first of all, thank you so much for such a warm welcome. And I take this opportunity to extend my best wishes and also I'm thankful to the authority for organizing such an nice seminar on this pertinent topic of criminal law and justice reforms, which will give the participants a well-laid platform to deliberate on the various aspects and facets of this topic, because it is such multifaceted. So I'm looking forward to a very insightful deliberations being done over the next 2 hours by the various participants. So thankful to the organizing members and the committee members for choosing this topic, which has given so much deliberations to the participants. And my best wishes to each paper presenter here. Looking forward to hear from all of you. Thank you.
Thank you very much, ma'am, for your words that have beautifully set the intellectual tone for this afternoon's deliberations. We will now proceed to paper presentations for this session. I request the participants to adhere to the program schedule and stick to the timeline. Each presenter will be given approximately 8 to 10 minutes to present their research, followed by remarks and observation of the chairperson and co-chairperson, if any. We shall start. Ma'am, may I introduce the first person?
Yes, please.
May I invite Ms. Mamta Bhavani Shankar Khandelwal to present her paper?
देखी नहीं, पूरा गाड़ी लाइट और सब चेंज हो गई है। और जब स्क्रैच पर चेंज नहीं था साइड हो, सब बटन सब चेंज हो गया।
Mamta ma'am, are you here with us? It seems like she's facing some technical issues. I will introduce the second person in the queue and we will take Mamta ma'am's presentation when she's available after this person, if that is okay. The next person is Mr. Kishan Pratap Singh Deora, Research Scholar, Institute of Law, Nirma University, Gujarat, and Dr. C.L. Yadav. They are going to be speaking on criminalization of existence, how stateless persons become victims of structural violence.
Thank you, ma'am. Can you please give me the hosting rights so that I can share the presentation?
Yes.
Ma'am, is the slide visible now?
Yes, visible.
Just give me a second. All right. A very good afternoon to one and all present here. I'm Kishan Pratap Singh, Research Scholar at Institute of Law, Nirma University. Today, I want to talk about something that affects millions of people worldwide, but remains largely invisible: the concept of statelessness. My paper is titled Criminalization of Existence: How Stateless Person Become Victims of Structural Violence. Let me start with the story. In the year 2019, a British woman named Shamima Begum had her citizenship taken away while she was in a Syrian refugee camp. Overnight, she went from being a British citizen to being nobody. No country recognized her as their national. She became what we call stateless. This might sound like an extreme case, but it's part of a much bigger problem. Right now, at least 4.4 million people worldwide are stateless. The real number is probably over 10 million. These are people who don't legally exist in the eyes of any government globally. To understand why this matters, I need to explain the structural violence. This term was created by a sociologist named Johann Galtung. Unlike physical violence, where someone attacks you physically, structural violence is harm caused by the society and the way society is organized, by laws, by policies, and by institutions. Think of it this way: if someone punches you, that's the direct violence. But if the law says that you can't work, you can't go to school, you can't see a doctor, and can't even prove you exist, that's structural violence. The system itself is harming you. For stateless people, this is their daily reality. They are not just missing paperwork, they are denied the most basic human right of all, that is, the right to simply exist. Now, here's the cruel part: stateless people get punished just for being alive. Let me explain how. First, they can't get identity documents. Then, they get arrested for not having proper documents. They can't work anywhere legally, but if they work informally just to survive, they will get arrested for working without permits. They can't rent homes legally, so they become homeless or they will squat somewhere. and then they will get arrested for trespassing. Many are put into detention centers, basically jails, just because immigration authorities want to deport them. But here's the catch. No country will take them because no country recognizes them as citizens. So they sit in these detention centers indefinitely, imprisoned for a status they can't change. This is what I call the criminalization of existence. Let me show you with some real examples. The most severe case is the Rohingya people in Myanmar. It was the year 1982 when the Myanmar government passed a law that deliberately excluded the Rohingyas from citizenship. About 1.5 million people became stateless in their own homeland. Without citizenship, they couldn't move freely, they couldn't go to university, they couldn't own land, couldn't even get married without government permission. Every part of normal life became illegal, became criminal. In the year 2017, this legal violence turned physical. Military killed thousands of people, systematically raped women, and burned hundreds of villages. Over 7 lakh Rohingyas fled to Bangladesh. Thousands came to India, and similar numbers to other Southeast Asian countries. But being stateless made the violence easier. They had no legal basis to claim protection, and the international community faced objections about interfering with the Myanmar's territorial sovereignty or internal sovereignty. Today, more than 1 million Rohingyas are stuck in refugee camps in Bangladesh, around 40,000 stuck in India, with no legal status and no rights. Children born stateless in these camps inherit their parents' rightlessness before they can even speak. So a person is born and the person already has criminality associated with his existence just because he was born to stateless parents. Now, let me talk a bit about India, which is particularly relevant for us. In the year 2019, the National Register for Citizens in Assam excluded 1.9 million people from the citizenship list. These are people who lived in India for generations but couldn't prove their ancestors were here before 1971. Why couldn't they prove it? Because the government never gave these poor, rural, and marginalized communities proper documents in the first place. Birth certificates, land records, school documentation, these were never issued to these illiterate populations in villages. Now the same government is turning around and saying, no documents, then you are not a citizen. India also has institutions called foreigner tribunals. These are supposed to determine who's a foreigner, but they operate without proper legal protections. Many cases are decided without the person ever being present. They will never get the notice or couldn't afford to travel repeatedly to hearings or couldn't afford a lawyer. As of December 2021, 44% of the cases were decided this way without hearing the person's side. And here's where it gets truly cruel. People declared foreigners are put into these detention centers or detention camps. The government is specifically, deliberately avoiding calling them jails, but they are jails for all practical purposes. As of 2019, over 1,000 people were detained. But between 1966 and 2023, less than 2.4% of those who were declared foreigners were actually deported. Now look at the scenario. Even if we declare 1,000 people as illegal immigrants or foreigners, we are not able to deport them to any other place. Why? Because Bangladesh won't accept them. Similarly, Myanmar won't accept the Rohingyas. So they sit in these camps indefinitely. 29 people have died in these detention camps. That is the official record. The Supreme Court has criticized the terrible conditions. No water, broken toilets, no medical care, but the camps continue to operate. In India, it has also become a political agenda. It is a rallying cry during elections. So every political party, lobbyist group has their own selfish interest or motive associated in perpetuating the problem rather than solving it. So why isn't the international law stopping this? The problem is the legal system itself has huge gaps. There are two main international treaties regarding this. The first one being the 1954 Convention, and there is a 1961 Convention. But India hasn't signed either one. Neither have many other countries. As of 2024, only 98 countries have signed the 1954 convention and only 79 have signed the 1961 convention. Even these treaties are weak. They provide lackluster, they have a very lackluster approach. They provide weak rights and support system to these people. They say stateless people deserve some rights, but those rights are less than what refugees get. And they don't give stateless people a path to citizenship. Similar things have been provided for refugees worldwide. So if you're a refugee in a particular nation, then there's a particular roadmap that after 5 years, after 10 years down the line, you will become naturalized and you will get an option to become national of that country. There is no similar provision or pathway for the stateless people as of today. So they just have permanent limbo, nothing more than that. The bigger problem is that the international law treats nationality as something states control, not something as a human right. So states can create stateless people and face little to no accountability. This brings me to some solutions that I propose. Traditional approaches have failed because they focus on states, not on the victims themselves. Our sub-theme was victim-centric reforms. We need victim-centric reforms, reforms that put stateless people at the center. And I propose three pillars to solve this issue. The first being the immediate protection. Every country should have a clear process to identify stateless people and give them temporary documents immediately. Secondly, stateless person should get the right to work, right to access education. They should also get access to healthcare so that they can live a normal life. We must end indefinite detention. No one should be jailed just because they are stateless. It is like penalizing the victim for being the victim. Second sort of solution would be the preventive measures. Every child born anywhere should automatically get citizenship with no exceptions at all. Some countries globally do have birthright citizenship, but the number is going down day by day. Even the champion of human rights, USA, is going to change its birthright policy. We must eliminate laws that discriminate based on gender, ethnicity, or religion. So, let's say in Middle Eastern countries, if someone marries a guy from Middle East, she can become citizen of that nation. But if a guy marries a girl from Middle East, they will never get citizenship. Similar provision are there in Pakistani law. Even in Jammu and Kashmir, state subject status was gender discriminatory till 2019. So we must eliminate laws that discriminate based on gender, ethnicity, and religion. Countries should only be allowed to take away citizenship in extreme cases and never if it makes someone stateless. Third part would be the restorative justice. As so many people have been wronged, over 1 million people have been wronged, we say state that created statelessness should compensate victims for the harm done. I know it would be extremely difficult to get executed. Long-term stateless residents should get fast-track path to citizenship. There should be some solution so that they can opt for citizenship nationality of at least one country. We need truth and reconciliation processes to acknowledge what happened and prevent it from happening again. So for India specifically, what can be done? First of all, we can impose an immediate moratorium. So we shall stop all new foreigner tribunal cases and review the old ones, especially those decided without proper hearings. We shall close the detention centers, release everyone immediately. If deportation isn't possible, which we practically know it isn't, then detention is just punishment without trial. So we can also suggest changes in the much debated Citizenship Amendment Act. India should also join the 1954 and the 1961 conventions to show commitment to these international standards. We need to create refugee-centric law. India needs proper legislation to protect refugees and give pathways to citizenship for children born here. We need to compensate victims who have been wronged by the foreigners tribunal. India needs people who went through foreign tribunal detention or NRC exclusion deserve compensation for what they suffered. Make sure that every child born in India gets registered immediately, regardless of their parent status. As in the juvenile justice law, we say that there's a doctrine of clean slate. No person is born as a criminal. Now, let me conclude. Statelessness is not just about bureaucratic problem. It's violence. It's systematic, institutionalized violence that makes millions of people invisible and strips them of their most basic human dignity. Hannah Arendt, a philosopher who studied statelessness, said the most fundamental human right is the right to have rights. Stateless people don't have this. They can't claim protection from any government. They exist physically, but they do not exist legally. In India, nearly 2 million people now face this uncertainty. They are not security threats or illegal immigrants. They are victims. This is something that we first and foremost need to recognize and acknowledge. Victims of system that value political convenience over human dignity. The time for change is now. We cannot continue criminalizing people simply for existing. Every person, regardless of nationality, deserves recognition as a human being with rights. Every child deserves to grow up with a future, not inheriting rightlessness from their parents. Structural violence against stateless people must end. We must build structural justice instead of that. Justice that guarantees that everyone has a place in this world, whether they everyone shall be assured that their voice matters and that their life has meaning. This is not an impossible dream, it is the minimum requirement of human dignity, and the victims of statelessness have waited too long. We must act now. With this, I would like to conclude. Thank you so much. If there are any questions, I would like to answer those.
Thank you for that very interesting and lucid presentation. Moving on, I'd like to invite the next presenter, Mr. Shiv Prasad, to present his paper on the evolving rights of arrestees under India's criminal procedure framework.
Yes, ma'am, I will present in this. Can you please allow my presentation?
I've given you the rights.
Yes. Just a minute, I will present now. Yes. Sorry for the technical. Yeah.
Okay.
I was unable to open the files.
I request the other participants to be ready with their presentations so that we don't lose on time and ensure that the seminar is conducted.
As of now, I can't take that. So should I present by speech?
I couldn't hear you very clearly. Could you please repeat?
As of now, I'm unable to open the file. So should I present through the speech, ma'am? Yes.
No problem.
Yes,
Preeti ma'am, that would be fine, right?
I mean,
Without
yes,
the PPT.
yes, no issues, no issues.
Thank you, ma'am. Yes, ma'am. Good afternoon, ma'am, and respected resource person and everyone who is present here. I am Shiva Prasad from Tamil Nadu National Law University, Tiruchirappalli. My topic for my paper is grounds for arrest and rights and duties of the arrestor and arrestee, with a special focus on the Bharatiya Nagarika Suraksha Sanhita 2023, which has now replaced the Criminal Procedure Code 1973 after nearly 50 years. This paper explores a central question: does the business truly strengthen personal liberty, or it has only repackaged the only old law in new language? Because arrest, as we know, it is not just a legal procedure, it is the most intrusive expression of the state power. The reform came after decades of concern over custodial violence, arbitrary arrest, and lack of transparency. The BNSS was introduced to modernize criminal procedure, promote digital accountability, and codify judicial safeguards. Yet, even in 2023, the same constitutional tension remains between the power of state and the liberty of individual. Article 20, 21, and 22 of the Constitution continue to stand as the guiding lights, reminding us that any deprivation of liberty must be fair, just, and reasonable. And I have made the chapters such as first, constitutional foundation. Arrest directly engage the heart of our constitution. Article 21 ensures that no one shall be deprived of liberty except by procedure that is fair and reasonable. Article 22 gives that every arrested person the right to know the grounds for arrest and to be produced before the magistrate within 24 hours. And Article 20 Clause 3 protects against self-incrimination. Together, they form what I call the constitutional trinity of the liberty. The BNSS tries to align every arrest provision with these three pillars. The arrest without warrant. Section 33-35 of the BNSS is the most crucial. It allows police to arrest without warrant, but only on creditable information and reasonable suspicion. And most importantly, only when it is necessary. This idea of necessity comes from the landmark case Jaginder Kumar versus State of Uttar Pradesh, where the Supreme Court held that arrest is not mandatory just because an offense is registered. Then came Arnesh Kumar versus State of Bihar, which is restricted routine arrest in offenses punishable up to 7 years. And finally, in DK Basu versus State of West Bengal, which gave us the now famous arrest guidelines like arrest memo, medical checkup, and intimation to relatives. The BNSS codifies all of this and even goes further. It requires officers to record the reasons for both arrest and non-arrest and to send arrest details digitally to the magistrate and the family of the accused. It also introduced stronger safeguards for the woman and elderly person. No arrest of woman after sunset unless under written judicial permission, and special caution when arresting someone above 65 years of age. All of these reforms sound progressive, uh, but their real test lies in the police station, not on the paper. And next comes arrest pursuant to warrant. Now, when we come to arrest by warrant, BNSS plays the power or under judicial supervision. Section 75 to 84 make it clear that a magistrate must apply judicial mind before issuing the warrant. This reflects the idea that liberty cannot depend solely on police discretion. It must pass through a filter of judicial scrutiny. The Act also recognized digital warrants, allowing digital electronic signature and digital communication within magistrate. This reduces delay and increased traceability, but also raises a practical concern. Technology is only as strong as system using it. In districts where digital infrastructure or training is weak, implementation could lag behind intent. And next comes the right of arrestee. Every arrest must be judged not by the power it grants, but by the rights it protects. The BNSS in sections 36 to 60 brings together the right to be informed on the grounds of arrest, not in vague terms, but in language and the person understands. The right to counsel reaffirmed in the Nandini Satpathy versus P.L. Dani, where the Supreme Court said that legal representation shields the individual from coercive interrogation. The right to medical examination, drawn from the D.K. Basu case, ensuring protection from custodial torture and continuing judicial control. The section and before said the 24-hour protection rule, which remains the backbone of the due process. The Act also reinforces the gender-sensitive arrest norm and digital record keeping, moving us towards the rights-based arrest system. But reforms in law means little without reform in practice. The BNSS has beautifully observed constitutional jurisprudence and statutory language, but the culture of arrest in India remains heavily discretionary. We still see cases where arrest is used as the first reaction rather than last resort. So the challenge is not only to train officers in technology, but in train them in a constitutional sensitivity. So, as I like to put it, a paper reform without a cultural reform in policy remains half of the reform. And to conclude, the BNSS 2023 does not reinvent the law of arrest. It refines it. It blends due to process with digital procedure and judicial oversight with accountability. Whether this becomes a tool of liberty or merely an updated CRBC will depend on how faithfully our institution carry it forward. And thank you for having your attention and this opportunity to share my thoughts. Thank you.
Thank you for the presentation. I now invite Mr. Arshad Alam to present his paper focusing on the intersection between technology, privacy, and procedural safeguards. Mr. Arshad Alam, are you here with us?
Yes, ma'am. 1 second.
Okay. Do you have a PPT?
No, ma'am. I don't have the PPT right now.
Problem.
Hello. Hello.
You're audible,
Yes.
Mr. Arshad. You may go ahead.
So, Jai Hind, everyone. The title of my paper is Technological Transformation in Criminal Investigation, Navigating Progress and Privacy under the Bharatiya Nagrik Suraksha Sanhita 2023. The Bharatiya Nagrik Suraksha Sanhita marks a digital evolution in India's criminal investigation procedure, shifting from colonial code of criminal procedure 1973 to a modern technological integrated model. The BNSS institutionalizes electronic documentation at every stage, like EFIR, summons and warrants, and mandatory forensic protocols under Section 176. The key reforms in BNSS include electronic FIR under Section 173, and there is a concept of zero FIR included in the BNSS as well. And it also mandated forensic investigation in serious offenses under Section 176. But on the other hand, as we know that safeguards and case laws are there for the protection of the privacy, these technological advancements are balanced by constitutional safeguards, particularly Article 21, right to life and personal liberty, which includes the fundamental right to privacy as affirmed by in Justice case Puttaswamy versus Union of India 2017, the Supreme Court established that any state-led digital surveillance must follow the triple test of legality, necessity, and proportionality. And we also have Digital for Personal Data Protection Act 2023 to ensure lawful processing, minimal data retention, and accountability. Other key references of case laws that I have discussed in my paper presentation is Menka Gandhi versus Union of India, on State of Punjab versus Baldev Singh, and Union for Civil Liberties versus Union of India 1997. But as we have certain technological advancement in the BNSS, on the other hand, we have certain challenges and regarding the implementation and recommendation for the overcome those challenges. Like challenges remain uneven technological infrastructure, inadequate policing training, inefficient forensic labs, digital exclusion risk, and data security concerns. To address these, recommendations include BNSS with other statutory rules that it should align with Data Protection Act 2023. We have to establish uniform protocols for search and seizure. We have to establish standardized electronic evidence and admissibility. We have to establish annual audits and independent oversight bodies and capacity building through district level forensic labs. Blockchain record authentication will also help, and digital literacy campaign for police, judiciary, and vulnerable communities are emphasized as crucial for effective and ethical implementation. I would like to conclude with the BNSS 2023 is a crucial step in modernizing India's criminal investigation process, integrating technology to enhance access, transparency, and effectiveness. However, it must be deployed with robust privacy protection, procedural fairness, and constitutional oversight, guided by landmark cases that I have discussed in my paper, which also ensure the technological advancement uphold the right and dignity of all citizens. Thank you.
Thank you for highlighting the practical challenges in integrating technology with investigation. Next, I invite Mr. Ganesh to deliver his presentation on custodial violence and its implication for human rights under the reformed criminal justice system.
Yeah, good afternoon, ma'am, and all. Am I audible? Am I audible, ma'am? Hello?
Yes, you are audible.
Okay. So basically, good afternoon, everyone. My topic is from detention to dehumanization, and that is examining the systematic root of custodial violence. We are very much aware about this word, custodial violence. Recently, we have heard the news of Tamil Nadu also in July 2025. So it came into the news that custodial torture and all. Basically, what is it means? It is given in the word itself, custody and torture. So whatever physical or mental is there in the police or any other authority, so that is a kind of torture which is under the, just a minute, sorry. Ma'am, presentation at least, okay. Yes. So basically, to start with, the meaning is it's like a torture that led to death in custody, or it led to any permanent injury or something like that. So basically, gruesome act that is committed by jail staff upon prisoners or So basically, it's a gross violation of human rights. We are the part of welfare state. We know very well, like being a democratic country and uh, a kind of like USA, UK, and in fact, every country, most of the countries of the world is following this concept of welfare state. So it's not only citizen, but I mean, prisoner, and in fact, we treat. I mean, we have seen the case of Ajmal Kasab and so many. We treat prisoners also as a like they have certain rights. We give Article 19, 2021 is there to protect them, but in this custodial violence, we used to see that gross violation of human right is there. And Article 21, that is the most important, that is right to life and liberty, is being violated. And it's not only physical torture, but it is also abusive behavior. It's including like psychological torment, that denying medical treatment, and all these things. So basically, it is not only physical torment, but it is a dignity. Dignity has been violated. It has been tempered. So the point is, what kinds of before that I would like to see one case law also, that is Sunil Batra versus Delhi administration, a very landmark, in which Supreme Court held that torture and cruel inhuman treatment within prisons which is violating the fundamental human rights. And we have heard the case of DK Basu also. uh, Now, types of custodial violence, it exists in various forms, that is physical violence, then psychological torture, and also coercing detainees. Now, what is the impact? Impact is very deep and multifactional. On personal level, the effect of violence leaves victim with a very severe physical, emotional, and social aftermath. It may rise to physical injury, wounded disability, and death in direct manner also. There are so many cases also. We have seen that we used to hear in news that in certain part of country, death is there, and so many news. So basically, it also shake the trust of prisoners in justice delivery, because they hate, they think that कि ऐसा हुआ है, so बाकी जगह पे भी होता होगा, we will, I mean, it's like a, they are, it is presenting the picture that it's all about justice, related to justice and all. So basically, it's in wider implication on governance, legal assistance, and public confidence. It is damning indiscipline of criminal justice system, that is revealing the mismanagement of police and prison, and also the failure of monitoring and lackluster accountability. NHRC, National Human Rights Commission, and also NGOs have highlighted the endemic nature of this problem. These violations, I mean, violation of like not following the norms and all. So basically, they are weakening the rule of law and also public trust in law enforcement institution, and it will create an environment which will abuse, can thrive. So basically, it leads to problem of overcrowding also. For example, it is estimated that under trial prisoners who have been subjected to custodial violence are more likely to experience mental health disorder. ये होता है. We have seen that person who is coming from jail, or if he has suffered something like that, torture हुआ है, तो it is there in his mind and he will share his experience to the others. तो वो भी वैसा सोचता है. So if we will say in some, custodial violence is violative of human dignity and treats the perpetrator as a non-human animal. Now, high-profile cases of death in custody and torture attract the public censure and press scrutiny and call for reforms. It will serve as a catalyst for policy shifts and judicial involvement. Now, basically, how we can eliminate it can be eliminated by adopting legal systematic, that is constitutional safeguard or judicial inquiry and administrative monitoring and grievance redressal as well. International norms, that is contained in Convention Against Torture and Other Cruel, Human or Degrading Treatment or Punishment, as well as United Nations Mandela rules, that is also has to be kept in mind. Basically, if I have to summarize, we can say it is a very complex phenomenon. Custodial violence is a complex phenomenon that entails physical, psychological, sexual, and structural victimization in detention facilities. And most importantly, it is affecting Article 21. Now, what is the cause? Cause is India is a very it's custodial violence in India is a very complex issue that is related to systematic, structural, and socio-economic aspect. By the way, as I discussed earlier, Article 21 and 22 is there, as well as international human rights standard is also there. But case of physical abuse, psychological coercion, and negative prison and police custody remain common. After, I mean, इतना होने के बाद भी it is there. Custodial violence, it is a systematic, it's a matter of routine follow-up in functionaries of criminal justice and police administration. One of the systematic structure is that there is overcorrection to punishment. मतलब we are not focusing on rehabilitation, overcorrection के ऊपर ज़्यादा चल रहा है, and also retributive and security functions is there. There is one case, DK Basu, as I have said, it has outlined that procedural safeguard also non-informed enforcement dilutes responsibility and perpetuates the culture of custodial violence. Now, I will not take much time. Now, role of police. Actually, cops and SPU plays a very crucial role in upholding the law. क्योंकि first stage police का है, when कुछ भी होता है कहीं पे police will come to the picture. So it is a very crucial role in upholding the law, keeping the peace and controlling correctional facilities. Despite all these functions, it is very incumbent upon prison authority to preserve human rights and prevent custodial violence. Indian police and its functionaries are bound by constitution establishment, law of land, and judgment of courts. The police are gateway for the people who come into the contact with criminal justice system. They have role of search, arrest, questioning, presentation to court, where there are such charges against some. Now, the law enforcing authority is interested with keeping the retrial prisoners, in which period their conduct, it's become very crucial to ensure that fundamental right that is guaranteed by 21 and 22 is not violated in any way. So police have twin obligation in matter of custodial violence. अगर देखा जाए तो it is twin. That is, first to prevent it, and second to ensure the responsibility when abuse is committed. Neglect, excessive force and torture as soon as police officer is accused of neglect. So, and last I will like to say, since it's very big, what are the Supreme Court and High Court directives? So basically, Indian courts they are very instrumental in suppression of custodial violence and implementation of human rights norms in criminal justice. Supreme Court and High Court have given so many directions to ensure that detention, questioning, and confinement adhere to the constitutional guarantee that is given in Article 21. Now, it has been crucial also in establishing the legal binding. As I said, DK Basu case, important guidelines is there. Now, one more case for under trial, that is Hussain and Aram Khatun. It was discussed that court pointed out the distress of under trial, that is languishing in jail for years without trial. When the trial only and they are in jail for longer years. So the point is, in that case also it has been highlighted. So basically, to conclude, I will say that I will like to, since it's very big. And yes, I forgot to mention one more thing. Law Commission in 273rd report, Law Commission has recommended that UNCAT 1984 and specific law has to be drafted. And also Commission has given a Prevention of Torture Bill 2017 to consider. It has given drafted the bill and government has to consider. But again, it is in the way. And NHRC also has recommended district magistrate and SP that they must report any incident of custodial torture to the Secretary General within 24 hours. And to conclude, I will say custodial torture is a very grave human rights violation in India, and it is exacerbated by legal gaps, institutional impunity, and systematic failures. Now, what will happen? What we can do? We can strengthen the law, like BNS reform is there, UNCAT ratification is there, and ensuring independent oversight and police accountability also. That's all I will say. Thank you.
Thank you, Mr. Ganesh, for that thought-provoking analysis. Next is Ms. Purva Gupta to present her paper exploring the intersection between electoral processes and criminal justice in India. Ms. Purva, are you here in the meeting with us? Ms. Purva, are you in the meeting? And I'll move to the next paper.
Sure.
Now I'd like to invite Ms. Kajal Kundalia and Mr. Rituraj Bhoval, PhD scholars, Raiganj University and University of North Bengal, to present their papers. Ms. Kajal, are you here?
Ma'am, am I audible?
Yes, you're audible.
Yes, ma'am.
Ms. Kajal, kindly start your presentation.
Ma'am, am I not audible? Hello?
Now you're audible. Now we can hear you.
Okay, ma'am, I'll start the presentation.
Oh, ma'am, maybe we can move ahead and we'll ask the participant to present towards the
Yes,
end,
ma'am.
if that's okay with you. I mean, I'm fine.
No
I have
problem. We'll move to the next paper. Ms. Kajal, you are taking too much time. Kindly hold your presentation for now. We'll move to the next.
Is she ready? Are you ready, Miss Kajal?
Ma'am, actually, I was presenting. Audible. Am I not audible?
No.
We are unable to hear you. Only
Actually, I
when you ask
completed
us that you are audible,
I
we are
completed
able to
half
hear
of
you.
my presentation. Actually,
No,
maybe there are some network issues.
because you were muted. That's why.
Shall I start again?
Yes, please.
Okay, all right, ma'am. Good afternoon to one and all present out here. So today I, on behalf of my co-author, Mr. Rituraj Bhawan, I would like to discuss or throw light on a topic which is legal, not only legal in its form, but it's deeply ethical in its essence. I'm talking about the principle of proportionality. So it's that invisible moral thread which binds law with justice. It ensures that punishment fits the crime and that power respects reason. So at its heart, the doctrine of proportionality, it whispers a timeless truth, that is, justice loses its meaning when punishment exceeds necessity. So it tells the state that yes, you may punish, but only to the extent you must. So in our constitutional landscape also, the doctrine emerges from the very soul of Articles 14, 19, and 21. As we all know that Article 14 guards against arbitrariness, Article 19, it insists on reasonable restrictions, and Article 21, it assures that liberty shall be curtailed only through a procedure which is just, fair, and reasonable. So together, these three articles, this golden triangle, it reminds us that a punishment which is excessive is itself an injustice. Even our judiciary has long acted as a torchbearer of proportionality. For example, in the case of Maneka Gandhi versus Union of India, it was very clearly laid down that any procedure which curtails liberty must be fair and reasonable. And thereafter, in the case of Om Kumar versus Union of India, the court formally adopted the European principle of proportionality, wherein it declared that state actions and penalties must balance purpose and means. So through these pronouncements, proportionality evolved from a theoretical doctrine to a constitutional command. So now as India steps into this post-colonial dawn of BNS, which is Bharatiya Nyaya Sanhita, the question arises that whether this new law truly embodies the proportional spirit which our constitution envisions. So the BNS replaces the IPC of 1860, which was a colonial relic built on deterrence and control, and it aims to create a citizen-centric and justice-oriented framework. But when we read it through the prism of proportionality, a nuanced picture emerges. So BNS classifies offences with remarkable precision. For example, a few sections dealing with homicide, sections 101 to 108, it deals with homicide and differentiates between murder, culpable homicide, and negligent acts, each attracting a punishment proportionate to intent and gravity. So this demonstrates a very clear legislative effort to align punishment with culpability. Secondly, if I talk about the colonial sedition clause, section 124A of IPC, which has been replaced by BNS, entitled Acts Endangering Sovereignty, Unity and Integrity of India. So even this is a very significant proportional step. Now only acts that incite violence or threaten sovereignty are punishable and not mere criticism of the government. So here the law acknowledges that dissent is not disloyalty, it's democracy's pulse. Thirdly, moving on to community service under section 4, subsection 2, clause F, this has been introduced as a punishment for minor offenses. I would not say this as a punishment because it represents a reformative shift, recognizing that justice is not always about punishments, it's not always about penalties, but also about transformation. So by replacing the short-term imprisonment with service to society, the law applies proportionality, not just in sentencing, but in spirit. If I talk about sexual assault and trafficking, also the BNS has introduced graded penalties depending upon the age of the victim, the role of the offender, the nature of the harm. However, not all provisions maintain such balance. And despite these progressive elements, India still lacks statutory sentencing guidelines. For example, two individuals committing similar offences often receive vastly different punishments depending upon judicial discretion. Even the Law Commission's 262nd report, which came out in 2015, it urged for structured sentencing. Yet the BNS leaves this largely unaddressed. Without a consistent sentencing policy, proportionality remains a promise and it cannot be practiced in this way. So in order to truly realize the spirit of proportionality within BNS, we need to codify sentencing guidelines based on intent, harm and context, and most importantly, we need to train the judicial officers and the law enforcers to apply proportionality as a constitutional lens, and it must be ensured that justice reforms and just not retaliate. So thank you. I would like to end my presentation.
Thank you, Ms. Kajal, for that presentation. Next, I would like to invite Dr. Nandini Raizada to present her paper on women's safety and the evolving jurisprudence on sexual offences. Dr. Nandini, are you here with us?
Excuse me, ma'am.
Yes.
This is Purva Gupta. My number has not been announced.
Ms. Purva, we did announce your name, but you were not in the meeting back then.
Ma'am, I was in the meeting. Maybe there was some connection problem due to which I couldn't hear or I was not able to connect with you. Hello?
Okay.
Ji.
Maybe
So,
we can try to accommodate you at the end.
At
Would
the
that be
end.
fine?
At the end.
Yeah, towards the end, Miss Purva, please. Okay.
Okay, ma'am. Okay, thank you.
We'll continue with the sequence as of now. Next in the sequence is Miss Dr. Nandini, ma'am. Is she here in the meeting? I believe she is not here. I'll invite the next person, Ms. Seema Roy.
Yes, ma'am.
On the fundamental right to humane treatment during custody and detention. Are you ready?
Yes, ma'am. Good afternoon. I am Seema Roy. I'm from Kolkata. I am a LLM student in Amity University, Kolkata. And today I would like to speak on the topic right to fair treatment and right to fair and humane treatment in custody. Every individual, am I audible?
Yes.
Every individual, whether in custody or not, they are they have the right to basic living. I'm sorry about that. Every individual, whether in custody or not, they have the basic human rights that cannot be taken away. This right are the constitutional remedies that has been provided under international as well as our national internationally as well as national laws. Like for example, Article 21 that talks about right to life and personal liberty. This article has been widened by our Honorable Supreme Court, which include right to dignity, uh, right to live with dignity, and in our international instruments like right to Universal Declaration of Human Rights and United Nations Convention Against Torture, they emphasize on the rights on. Can I keep my camera off?
Yes, you can.
Okay, so emphasize on subject to cruelty, inhuman or degrading treatment and punishments. In significant cases like DK Basu versus State of West Bengal, where the Supreme Court has given guidelines for um, the, I mean, guidelines for the torture this against this torture. Like for example, right to inform to their relatives, right to the medical checkups, and right to be informed about the arrest. I'd like to conclude by saying that justice can never be, served without fair trial. Thank you.
Thank you for the presentation. Now, next, I'd like to invite Ms. Jayashri to share her research findings on the under trial crisis and the impact of India's new procedural code. Ms. Jayashri, are you in the meeting?
Yes, ma'am. A very good afternoon to all the dignitaries and my fellow participants. I am Jayashri. Ma'am, am I audible?
Yes, you are.
Yes. Yeah. I am Jayashri Rajvanshi, a research scholar of National Law University, Assam. So I would like to thank the organizers for giving me the opportunity to share my insight on this paper. At the same time, I'd like to share the screen. Ma'am, is it visible?
Not visible.
Just give me 2 seconds.
Yes, it is visible now. Kindly unmute.
Uh, hello.
Yes.
Ma'am, I hope I'm visible as well as audible.
Yes, you are.
Fine. So the title of my paper is New Criminal Laws and Under Trial Crisis, Insights from Assam. So as we all know, in December 2023, the Parliament of India passed the three new criminal laws, the Bharatiya Nagarik Suraksha Sanhita, the BNS Bharatiya Nyaya Sanhita, and the BSA, Bharatiya Sakshya Adhiniyam. So these three new criminal laws replaced the colonial era legislations, and it came into effect from 1st of July 2024, which represents the biggest overhaul of India's criminal justice system since independence. So at the time of enacting these laws, so when it came into force, it an explicit promise of speedy citizen-centric justice. So the official communication at that time framed the reform as justice-oriented rather than punishment-oriented, prioritizing the speedy trial, timely justice, and protection. The Prime Minister described these reforms as a move towards a time-bound, citizen-focused justice system, while the Union Home Minister highlighted their role in speeding up trials and restoring public justice. Yet, the impact of these changes must be measured not merely in legislative text, but in the lived realities of under-trial prisoners, who constitute nearly 3/4 of India's prison populations. So in this slide, I'm just going to discuss about why the under trial prisoners matters, or why am I taking up the topic of under trial prisoners in this paper. So ma'am, the latest national data shows that India's prisons still run well above capacity and remain dominated by UTPs, which is around 74% of the total prisoners in 2023. Or we can say it is around 4 lakhs out of 5.3 lakhs inmates, which is a very alarming rate, which is a very high rate, we can say. So since this paper is focused on Assam, the Assam's picture central to this paper's fieldwork illustrates the paradox. Like as of 31st December 2023, the jails of Assam has housed 7,546 inmates, like under trial prisoners, out of total 10,652 inmates. I'm again repeating the figure. Out of 10,652 inmates, it is the under trial prisoners alone consist of 7,546, which stood above 105% markedly from 2018. So these aggregates mirror the national structure constraints that new statutes alone have not yet corrected. The bail inaccessibility tied to poverty and surety conditions, adjournment-driven delays, strained delay age, patchy adoption of technology-enabled process, and underperforming under trial review committees. So moving on to the next slide. So the promises, as the three new laws have given us a promise of speedy trial and all, the true measure of India's new criminal justice framework will be tested not by the number of provisions rewritten, but by the extent to which it restores dignity, liberty, and fairness to the under trial prisoners. So the reforms which will acquire legitimacy only when justice for UTPs moves from aspirations in the statute books to reality on the ground, ensuring the constitutional promise of Article 21, which is not reduced to a hollow guarantee. So these are the core problems which I have already mentioned. So ma'am, these problems I have found after conducting my empirical studies in the district jails, that I will come in the objectives. So the statement of problem is this new criminal laws, despite the legislative changes in 2023, this under-trial population remains one of the highest globally. The BNSS attempts to impose strict timelines, extend electronic trials, and modify provisions for bails, etc. However, the gap between law on paper and the condition of under-trial prisoners on the ground still remains the same. So moving on to the objectives of the study, the first objective is to evaluate whether the new criminal laws, the BNSS and BSA, have reduced the prolonged under-trial detention by improving the bail access, trial speed, and procedural efficiency. The second objective is to assess on ground realities in Assam through field work in the 7 district jails and a case study of 11 UTPs examining how poverty, legal aid, and institutional functioning affect the implementation of the new laws. So for the purpose of the study, I have adopted a mixed method, the doctrinal method, in which I have examined the provisions of the laws and the constitutional safeguards, and I have also reviewed the case laws, NCRB data, law commission reports, etc. And on the part of empirical fieldwork, I conducted a extensive fieldwork where I have traveled into different jails. I have interacted with the superintendent of jails. I have also interacted with the various under trial prisoners and listened to their side of the stories, their interactions with the government advocates and all. So this literature review I'll skip due to time constraints. So in the analysis and findings, what I have found is, I'll just go through a few case laws that I have noted down from my study. So in the case 1, these are real cases. I have just changed the name for the sake of privacy. So in case 1, Rahul and Imran, they were booked under the POCSO Act, and they had no communication with their families and remained entirely dependent on legal aid lawyers who barely interacted with them. The reason was they were poor enough to hire private advocates for them. So the case 2, Amit and Kamal, they were accused of murder, but they were benefited from private legal representatives, enabling them to remain better informed about their case status. So in these 2 cases, what I am trying to show is that in the first case where in the case of Rahul and Imran, they were less informed about the status of their cases, or you can say they were not even aware about their trial, on what stage they are, what are the charges under which they were booked. But in case 2, where Amit and Kamal, they hired private advocates, they were well aware of their matter because they had their advocates who were in good contact with them. Case number 3, it is about a person named Suresh. His original name is different. So the moment a person is arrested, family structures often begin to fracture under the weight of shame and exclusion. The same thing happened with Suresh, who was charged with theft, and he was abandoned by his wife, who could not endure the community disgrace. Again, in case number 4, prisoners like Sunil, Ravi, and Imran disclosed their acute symptoms of depression, hopelessness, and suicidal tendencies. So Sunil's anguish was more heightened when he was not permitted to perform the last funeral rites of his father, a denial that aggravated his trauma. So these were a few case laws which I shared. There are many case laws. These are just a few examples. So after visiting the jail, I was totally shocked to see the mental trauma of the under trial prisoners that they are going through. So I can only, or we can only hope that these new criminal laws would come up with some good results that would give some relief to these under trial prisoners.
Very sorry to interrupt, but kindly wrap up your presentation within a minute. We're way over
Yes,
the
yes.
time limit.
Yes. So I can skip with the findings then, if required, if there is a time constraint. I have already given my findings. So in conclusion, I can say that we can just hope that these new criminal laws give some relief to these under trial prisoners. Thank you.
Thank you, Ms. Jayashree, for the wonderful presentation.
Thank you.
We will now move on to the next participant. Ms. Mona Lisa, are you ready with your presentation?
Yes, ma'am. Just give me 2 minutes. Yes, ma'am. Ma'am, I would like to show a presentation, but kindly allow me
Yes, I've
as a
given you the
presenter.
rights. You can now share the presentation. Yes, Mona Lisa, you're not audible. Are you able to hear me?
Yes, ma'am. Just a second. The network issue. Just a second. Ma'am, I think there is a issue while showing my PPT over here. Is it okay if I continue without the PPT?
Yes, no problem.
Am I audible?
Please continue.
Okay. Thank you so much, ma'am. Good afternoon, one and all present over here. I am Mona Lisa Mukherjee, Research Scholar of Sister Nivedita University, Kolkata. And I am presenting my topic, which is titled as Evaluating the Implementation of Victims' Right in India's Legal System and Overview. Before I begin with my presentation, I would like to thank the organizers who have given me the opportunity for presenting the paper. Starting with an introduction of my presentation, I had quoted with of my presentation that why in the history has everyone always focused on the guy with the big stick, the hero, the activist, to the neglect of the poor law who has at the end of the stick, that is the victim, or the pacifist, or maybe the poor law isn't all that much of a pacifist victim. Maybe he asked for it. This is a famous quotation which is quoted by Hans von Henting, who was a German criminal psychologist and a politician, who quoted this to illustrate that in the past, there was a lopsided focus on the criminal event and the person acting in violation of the criminal laws. And for centuries, for legal philosophers and lawyers, they have been focusing upon the preoccupied with the principles of the criminal law, but their point of departure was always the offender, but never the person who suffered as a result of the crime. In around 1940s, academics who also started to have taken interest into the victims of crime and the standing in criminal procedure evolved the criminal justice system into the concept of victim's right. When we talk about the victim's right, the first and essential foremost thing that is important to know, that is the definition of the victim, which has been defined under the UN Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power 1985 under Article 1 and Bharatiya Nagarik Suraksha Sanhita 2023 BNSS under Section 2Y. Due to the time constraint, I'm moving forward to the historical background of the emergence of the victim rights, which had started with the early and colonial eras to post-independence to late 20th century and to the modern era of it. While early and colonial eras, this refers to the historical background of victims' right in India, shows a shift from an offender-centered system to one that is increasingly victim-focused and influenced by the international declarations, progressive and judicial decisions. Not going into the details of what the pre-colonial India stated, in ancient times like Rig Vedic era, victims had significant power to punish offenders, though this gradually shifted to the state. Early Indian law had limited provisions for the restitutions like those in the Code of Criminal Procedure in 1898, but a major catalyst for a change was in the UN's Declaration of Basic Principles of Justice for Victims' Crime 1985, evolved as a significant legal development, including the amendment to the CRPC. When we refer to the next slides of my rights of victim, which treats as the access to justice and the fair treatment, there are many rights of the victims, but when we consider, when we go to the essence of it, I found completely 6 essential rights of the victim which should be addressed. That is access to justice and fair treatment, right to restitution, right to compensation, right to victim assistance, right to speedy trial, and right to privacy. The government measures for the victim support services has also been taken, and which has been addressed as financial and legal support, under which victim compensation schemes, central victim compensation funds, legal aid and protection officers are the major key points into it. Where the victim compensation scheme, central victim compensations fund have been established in India to eradicate and support the problem of the schemes which has been provided. Along with the financial and the legal support, shelter and counseling is one of the very much important part of the government major schemes which the government has been providing these days. That is one-stop centers which provides integrated support including medical aid, police assistance and legal counseling. Apart from this, we have 3 more projects, that is projects 3 Manuraksha, Mission Shakti and Mission Vatsalya. To go in brief, projects 3 Manuraksha, which was launched in the year 2022 by Ministry of Women and Child Development in collaboration with Nimhans Bangalore to improve the mental health of the women in India, has been supporting in the counseling and the psychological support of the women. Mission Shakti, whose objective is to provide all the women and the girls, including differently abled, socially and economically marginalized, vulnerable groups in need of the care and the protection, and Mission Vatsalya, which is centrally sponsored scheme to provide a secure and healthy environment for the development of children. The scheme support for both institutional and non-institutional care for the children. Apart from this, according to a few data which I had collected for the National Data Information, data states that from 2024 and 2025 reports of NCRB, it highlights the significant challenges in implementing the victims' rights schemes in India, particularly regarding the inadequate awareness, bureaucratic delays, and inconsistent state policies. The critical challenge which I have analyzed during writing this paper was that the schemes which were introduced by the government is personally and professionally facing much more challenges in the present legal system under the following heads, such as bureaucratic and implementation issues and the lack of adequate support services. Under the bureaucratic and implementation issues, there are much delays in the compensation and the implementation gaps are in huge. There is a lack of victim-centering protocols, limited access to legal aid, insufficient psychological support, and lack of protection and lack of awareness of rights. What I felt that was due to the lack of awareness, since we do not have such rules and regulation which states the main rights of the victims, and there is no such rules and regulation which is mentioned under it. we are going and facing these challenges. There are a few landmark judgments which have proved in both positive and negative impacts on the rights of victims. When I would like to discuss on the positive impact, there are many cases, but I would like to highlight upon two cases. First is Rudal Shah versus State of Bihar in 1983, which was a pivotal case where the Supreme Court for the first time used its power under the public law to award monetary compensation of 35,000 for illegal detention and violation of fundamental rights under Article 21, which established a precedent that the state is liable to compensate victims for the arbitrary actions of its officials. And Sampurna Behrua versus Union of India case 2018, which is also a landmark public interest litigation that prompted the Supreme Court to direct states to establish crucial child protection infrastructure, which ultimately paved the way for the creation and the implementation of the Mission Vatsalya scheme. And along with this, there are two more landmark judgments which highlights upon the negative impact or the negative evaluation of the victim, that it is not highlighted in such a way. Rajesh Thopil versus DLSA Kannur in 2024 and Rinsi versus State of Kerala in 2025, these recent High Court cases explicitly illustrate how victims still face significant delays in receiving timely and full compensation, often waiting months or years and having to approach the courts to compel authorities to fulfill their obligation. These judgments expose the ongoing bureaucratic inefficiencies and the administrative hurdles that victims must have navigated. Hello, am I audible?
Yes, you are.
Okay, thank you so much. Apart from this, I have one more landmark case, that is Shiv Kumar versus Hukam Chand in 1999 and Rekha Muraka versus State of West Bengal in 2020. This case has also underscored the limited role of victims' private counsel in a criminal trial. The courts held that the victims' counsel can only assist the public prosecutor and cannot directly examine or cross-examine witnesses. This case highlights a practical limitation on the victim's right to active participation and control over the proceedings affecting their cases. There are a few suggestive measures to be taken by the government, which I have already mentioned in my slide. That is to enact comprehensive victim right legislation, mandatory victim consultation and information, strengthen compensation and restitution of law, implement effective witness and victim protection programs, institutionalize victim-friendly procedure, establish integrated victim supports unit, mandatory sensitization training, and public awareness campaign. To conclude my presentation, I would like to say that justice delayed is justice denied. And this maxim holds particular significance for crime victims who seek not only legal redressal but also dignity, rehabilitation, and closure. While India has made commendable strides in recognizing victims' rights, the true measures of a justice system lies not in the laws it enacts, but it lives and transforms. Practical implementation requires a sustained commitment from all the stakeholders like legislature, judiciary, executive, and civil society to ensure that every victim receives not only justice but also respect, support, and restoration of dignity. And the journey begins from recognition to realization continues. Thank you so much.
Thank you, Ms. Mona Lisa, for your reflective presentation. Next, on the queue is Ms. Anjali. Ms. Anjali, are you in the meeting? Ms. Anjali, Research Scholar, Institute of Law, Nirma University. Are you here to present your paper? Seems that she's not here in the. I now invite Mr. Shivendra Pandey and Dr. Rahul Singh to present their paper.
Very good afternoon to all the respected dignitaries and my fellow participants. I am Seven Pandey from Professor Rajan Singh Rajuvia University, Prayagraj, with my co-author Dr. Rahul Singh, Assistant Professor, Professor Rajan Singh Rajuvia University. I am here to present my research paper on topic ensuring justice through due process right of the arrested person in present day India. The concept of liberty is the cornerstone of the democratic polity. And the right to life and the personal freedom constitute its soul. The Indian Constitution, through Part 3, embodies its principle by guaranteeing protection to individual against arbitrary state action. The former of the Constitution in ways that no person should be deprived of liberty except according to a fair, just, and reasonable procedure. However, interface between law enforcement power and civil liberties has historically been marked by tension and misuse. Arrest, while the essential tool of a criminal investigation, often become a site of abuse when used arbitrarily or without procedural fairness. The National Crime Report Bureau (NCRB) data constitute reveals a significant number of pre-trial detention in a prisoner, resigning a serious question about the absence of a procedural safeguard. The Supreme Court has repeatedly emphasized that arrest should not be routine but justified by the necessity and proportionalities. Justice Krishna Iyer observed in Menaka Gandhi versus Union of India that procedure established by law must be fair, just, and reasonable. This study therefore seeks to examine a multidimensional aspect of the rights of the arrest person under Indian law. It investigates the historical evolution of the statutory guarantee and the judicial interpretation from that form a bedrock of procedural justice. Furthermore, this right within international human rights norms explore the impact of recent changes introduced by the Bharatiya Nagrik Suraksha Samhita 2023. The concept and constitutional basis of a due process. The phrase due process of law, through not explicit mentioned in the Indian Constitution, has founded substantive existence through the judicial interpretation. Originally, Article 21 merely required that no person be deprived of life or liberty except according to the procedure established by law. The farmer deliberately avoided the term due process, fearing excessive judicial interference. However, through a serious landmark decision, Indian courts have read due process into the constitution, transforming procedural safeguard in the substantive guarantee. In A.K. Gopalan versus State of Madras, the Supreme Court initially took a narrow view, holding that once a law prescribed a procedure, its fairness could not be questioned. The formalistic interpretation, subordinate liberty, and legislative supremacy, the tide turned by with Manika Gandhi versus Union of India, where the court harmonized Article 14 and Article 19 and Article 21 to hold that any law deprived liberty must satisfy the test of fairness, reasonableness, and non-arbitrariness. This marked the birth of substantive due process in India. Consequently, every arrest and detention is now tested not merely for the procedural validity but also for its conformity with the principle of fairness and probability. Article 23 through criticizes for its limited protection in prevention detention cases, nonetheless provided minimum procedural safeguard such as a right to be informed on the ground of arrest, the right consult a legal practitioner, and right to be the produced before the magistrate within 24 hours. The procedural law regulating arrest and detention in India primarily governed by the Code of Civil Procedure 1973 CRPC, now replaced by the Bharatiya Nagrik Suraksha Samhita 2023 BNSS. Article 21 and 22 of the supplemented by judicial guideline and international human rights obligation. In Joginder Kumar versus State of UP, Supreme Court held that the power to arrest must be exercised judicially, not mechanically. The court observed that no arrest can be made because it's unlawful for a police officer to do so. The existence of a power arrest is one thing, the justification for the exercise of it's quite another. Further, in DK Vasu versus State of West Bengal laid down exhaustive guideline to prevent custodial torture, mandating identification of arresting officer, preparation of arrest memos, and medical examination of the accused. The intimation of the family member, this direction were later incorporated in section 41B of the CRPC, giving them statutory recognition. The Bharatiya Nagrik Suraksha Sanhita 2023 represents the most significant overhaul of the criminal procedure law since independence. Although the provision relating to the arrest largely minor, those of the CRPC several reforms aims to be modernize procedure and enhance transparency. Section 35 of BNSS corresponds with the Section 41 of CRPC, but emphasizes the recording of a reason in writing before effecting arrest and provided for electronic documentation. In BNSS also introduced provides for a digital case record, electronic communication of arrest, a magistrate, and mandatory videography of a certain procedure. While these reflect a move towards procedural modernization, criticize argue that the law fails strength accountability. Judicial oversight function, the constitutional checkpoint against the arbitrary detention, Section 57 of CRPC, now Section 58 of BNSS, mandate that arrested person must be produced before magistrate within 24 hours of arrested. Exclusively travel time, Article 22, Clause 2 of the Constitution inherits the principle of fundamental safeguard. In a state of Punjab versus Azib Singh, the Supreme Court underscored the non-protection before the magistrate within the prescribed time, rendered the detention is illegal. Furthermore, Arnesh Kumar versus State of Bihar directed that police officer must issue notice to appearance under Section 41A, now Section 37 VNSS, instant arrest individual for the offence punishable with the imprisonment of a 7 year or less unless necessary. Judicial safeguard of interpretative trends, judicial expansion of Article 21, the watershed moment for a procedural fairness in India came in Menaka Gandhi versus Union of India, where court linked the Article 14, 19, 21 holding that procedural established by law must be right, just and fair. This laid foundation for a jurisprudence of the right that extend beyond textual limitation. The decision transformed Article 21 from the procedural clause into the respiratory human dignity. In Husnaira Khatun versus State of Bihar, the Supreme Court recognized the right to speedy trial as an essential component of Article 21. Similarly, Sheila Varshe versus State of Maharashtra refrained that right to the legal aid in a fundamental aspect of fair position. The evolution of due process under Article 21 has thus created a constitutional ecosystem that restrains executive access that enhance the right of arrested person. Protection against custodial violence. Custodial violence remains one of the gravest human right concern in India. In DK Vasu, the Supreme Court declared that torture, physical or a mental, in a violation Article 21 of a constitute and affirmative to the human dignity. The court prescribed 11 detailed guidelines governing arrest and detention, later codified into CRPC provision. In Tilvati, Behra versus State of Odisha, compensation was awarded to the victim mother, reinforcing the principle the state must repair and damage caused by the officer. principle bail and the presumption of innocence is a cardinal principle of criminal jurisprudence. Bail, therefore, serves a mechanism to balance individual liberty with the interest of justice. Section 436A CRPC, now 479 BNSS, mandate release of a unretrieved prisoner who have served half of the maximum punishment. In Satyendra Kumar Until versus CBI, the Supreme Court restrained the bail should be the rule and jail is the exception, directing that unnecessary arrest violate both Article 21 and personal dignity. Universal regional norms. The rights of a arrested and detained person are deeply rooted to the International Human Rights Article 9 of the Universal
Mr.
Declaration,
Shivendra, sorry to
Declaration of
interrupt
Human
you,
Rights.
but
Yes, ma'am.
kindly wrap up your presentation in the next 2 minutes.
Okay, sure, ma'am. Uh, now, I'm begin with my conclusion. The right of an arrested person represent the moral, constitutional test of any democratic community to the justice. From A.K. Gopalan to the Puttaswamy, Indian jurisprudence has gradually evolved from the procedural formalize the substantive fairness, add to the recurring parent, missing delays, and institutionally neglect the undercourse that law alone cannot guarantee liberty. Implementation is the true determinant of justice. Thank you so much.
Thank you so much, Mr. Shivendra, for your presentation. Now we move to Ms. Tabassum Beg to present her paper on property rights and justice reforms for Muslim women.
Yes, ma'am. Good afternoon, everyone. Good afternoon, Chairman, good distinguished guests, and fellow scholars. I'm Tabassum Beg, a research scholar from G.H. Raisoni University, Saikheda, and today my research paper on Muslim women's property rights and justice reform. The abstract of my paper, the right to property is not merely a legal entitlement, but a reflection of human dignity, equality, and justice in Islam. Women were granted property and inheritance rights over 14 centuries ago, a revolutionary recognition in a world that otherwise treated women as dependents or property themselves. Yet in contemporary societies, Muslim women continue to struggle to claim these divinely ordained rights. My paper explores the gap between Quranic principles and socio-legal realities, highlighting the cultural, legal, and institutional barriers that prevent Muslim women from enjoying their rightful shares. It further purpose reforms grounded in Quranic justice, legal enforcement, and social awareness to ensure the true gender equality, equity, and justice. The introduction of my paper, Islamic law through the Quran and Sunnah granted women the unprecedented right to inherit, own, and manage property. The Quran states unequally. Surah, chapter 4, verse 7. For man is a share of what the parents and close relatives leave, and for woman is a share of what the parents and close relatives leave, be it little or much, a determined share. This divine mandate revolutionized pre-Islamic customs, yet today, many Muslim women, including in India, face obstacles such as social coercion, lack of awareness, and patriarchal customs that undermine these rights. The challenge is not the absence of right in Islam, but the failure of justice systems and communities to uphold them. Hence, justice reform in both religious interpretation and legal enforcement is essential. Literature and legal background. Islam's legal framework for women's property rights is rooted in the Quran, chapter 4, verse 7, 11, 12, 30, 32. And scholars such as Asghar Ali Engineer and Amina Wadud emphasize that Islam recognizes women as independent legal person. entitled to property and income. However, as Ziba, Miri Husseini, and Naeem noted, patriarchal traditions have diluted this principle, leading to gendered inequities in inheritance. Indian courts have upheld women's rights in several landmark judgment cases. Shabano Begum versus Muhammad Ahmad Khan, 1985, recognized Muslim women's financial rights. Case number 2, Bushra Bibi versus Irfan Ahmad, 2012, reaffirmed women's entitlement to inheritance under Sharia and Indian law. And Ghulam Mustafa versus State of Maharashtra, 2020, emphasized that customs cannot override Quranic injunctions. Despite this, implementation remains weak and women continue to face prolonged litigation, coercion, and ignorance of their rights. Challenges in practice. Point number 1, patriarchal pressure. Women are often pressured to renounce their shares for the sake of family peace. Point number 2, lack of religious and legal awareness. Many women are unaware that inheritance is a divinely sanctioned right, not a social favor. Point number 3, customary practices. Traditional customs often replace Quranic laws, denying women equal rights. Point number 4, judicial delays and barriers, prolonged litigation and lack of access to legal aid discourage women from seeking justice. Point number 5, economic dependency. Financial reliance on male relatives silence women's voices in property matters. Justice and reform. The Quranic vision. The Quran envisions justice and balance in all social relations. Denying women their inheritance is a violation of this divine justice. Give the shares to those who are entitled to them. Sahih al-Bukhari. Reforms must therefore begin by returning to authentic Quranic guidance supported by modern legal mechanism and community accountability. Recommendations for justice reform. Religious point number 1, religious revival and awareness. Community leaders and imams should emphasize women's inheritance right during sermons. Quranic literacy program for women can promote self-awareness and empowerment. Point number 2, legal reform and fast-track justice. Establish family inheritance tribunals to ensure speedy resolutions of women's property claims. Enforce strict penalties for coercion or fraudulent transfer of property. Strengthen free legal aid for marginalized women. And the third point is education and economic empowerment. Introduce gender and property right education at school and university levels. Support women's access to microfinance and vocational training to reduce dependence on male relatives. Point number 4, judicial and policy intervention. Train judges and lawyers on gender-sensitive interpretation of Muslim personal law. Integrate Quranic justice principle within India's family law reforms. The conclusion of my paper, women's property rights, Muslim women's property rights are not a gift of modern law, but a divine entitlement bestowed over 14 centuries ago. The Quran's justice framework recognizes women as equal moral and legal beings. However, justice reform is necessary to bridge the gap between divine law and human practice. Empowering Muslim women to claim their property rights is not merely an act of gender equality, it is an act of faith, justice, and reform. The path forward lies in harmonizing religious authenticity and with legal enforcement and social changes, ensuring that the Quranic vision of justice become a lived reality for every woman. Okay, thank you, ma'am.
Thank you, Mr. Basum, for your presentation. Next, I invite. Am I audible? I'm facing some technical issues.
Yes, ma'am.
Next, I invite Ms. Manisha Das to present her paper. Ms. Manisha, are you here?
Yes, ma'am. Am I audible?
Yes, you're audible. Are you
Ma'am,
going to present a PPT?
yes, ma'am. Can you make me the presenter?
Yes.
Is my PPT visible?
No, it is not visible.
Okay. I am okay, then I'll be starting without PPT. So a very good afternoon to everyone. Today I'll be presenting on the topic liberty before custody, that is India's arrest law as a constitutional restraint regime in comparative contrast with the USA and Brazil, and how India outperforms them. So the first slide that suggested the liberty before custody, which is India's arrest law, is designed to protect personal liberty even before a person is taken into custody, compared to countries like the United States and Brazil. India's framework places much stronger constitutional safeguards right at the moment of arrest. I will be focusing on how and why India's system is structurally superior, how this safeguard works, and where enforcement needs improvement. So, what is arrest? Arrest means the act of taking a person into legal custody upon that person's offense of the state law, which is only done through enforcement of law, where the arrestee is physically detained, that is, handcuffed, and told that they have been arrested or they are under the arrest. Coming to the next slide, that is slide 2, why arrest law matters. Arrest law occupies a constitutional, not merely procedural domain in the Indian legal system. The power to take a person into custody is the most intrusive executive action short of conviction, and therefore is subject to the discipline of Article 21 and 22 respectively. After Maneka Gandhi versus Union of India case, which was in the year 1978, expanded the meaning of procedural or procedure established by law to require both fairness and non-arbitrariness at every stage of liberty deprivation. In this case, it was held that the legality of an arrest must be judged at the moment it is carried out and not postponed to the stage of trial. This makes arrest a constitutional right subject to reasoned justification. The remedies in case of arbitrary arrest also include habeas corpus, bail, compensation, departmental action, and judicial complaint, all rooted in the protection of Article 21 and Article 22 of the Constitution. Judicial remedies also include filing a criminal complaint against the officer for wrongful confinement under sections 341 to section 348 of IPC. So moving on to the next slide, that is slide 3, which talks about the India's constitutional foundation. Article 21 requires that every action affecting liberty must follow a fair, just, and reasonable procedure. Article 22 adds immediate rights for any arrested person, including being informed of the reasons for arrest, being allowed to consult a lawyer, and being produced before a magistrate within 24 hours. What makes India unique is that these safeguards apply at the exact moment the arrest happens. Our constitution places liberty above convenience and ensures rights from the very first second of custody. In the slide 4, we will be dealing with the important Supreme Court cases. First being Joginder Kumar versus State of UP, which was in the year of 1994. Joginder Kumar, a young advocate, was called by the police for questioning um, in connection with an inquiry. The issue which was raised was whether a person can be arrested by the police merely on suspicion, and what safeguards exist against arbitrary arrests. Uh, the uh, the judgment which was delivered in this case by the Supreme Court stated that firstly, arrest should not be routine. Secondly, no arrest can be made simply because it is lawful to do so. Thirdly, the right to personal liberty under Article 21 of the Constitution is fundamental, and arbitrary arrest is a violation of this right. Fourthly, the police must inform the person's relatives or friends about the arrest and where the person is being detained. The next case is of DK Basu. In this case, the issue was what guidelines should govern arrests and detention to prevent custodial torture and deaths. The judgment of this case held that custodial torture and deaths violates Article 21 of the Constitution. To protect this right, the court laid down specific guidelines for the police and the magistrate to follow. In the case of Arnesh Kumar, the accused under Section 498A IPC, the issue was whether arrest under Section 498A similar offences should be automatic or based on judicial scrutiny. The Supreme Court emphasized that arrest is not mandatory in every case where the offense is punishable with imprisonment up to 7 years. Police must justify the necessity of arrest. In the case of Nilabati Behara versus State of Odisha, the issue raised was whether the state is liable to pay compensation for a violation of the fundamental right to life caused by custodial death. The judgment made monetary compensation a recognized public law remedy for custodial deaths and police excesses. Coming to slide 5, section 41 of the CRPC clearly says that arrest should happen only when it is necessary, such as preventing escape, stopping interference with evidence, or preventing further offenses. The officer must write down the reasons, and failure to do so makes the arrest unconstitutional. This system prevents impulsive or abusive arrests and ensures that arrest is always a carefully justified act. Lastly, I would like to say whatever there is in slide 8, that is the main topic of the paper, which is the comparative lens between US, Brazil, and India. When we compare India's arrest system with other countries, the differences are striking. In the United States, probable cause alone is enough for full custodial arrest, even for small offenses, and rights like the Miranda warning can be waived. Brazil, on the other hand, heavily relies on preventive detention, which contributes to prison overcrowding and delays. Whereas India stands out because it requires both legal authority and recorded necessity to arrest, along with the real-time rights and immediate judicial oversight. This makes India's model the most liberty protective amongst the other. In conclusion, I would like to say that this particular paper entirely focused on India's arrest law is not only well designed but also constitutionally superior to both US and Brazilian laws, since India perceives arrest from a matter of procedure into a matter of constitutional accountability. Perhaps the defect is not in the architecture but in its execution. The answer lies in enforcement of architecture like digital compliance, judicial filtration, officer liability, and cognitive restraining. Without altering the superior normative structure India already possesses, India does not require external correction, it requires internal fidelity to its own constitutional commitments. Thank you.
Thank you, Ms. Das, for that comparative discussion.
Yes.
I now invite Ms. Shikha Sotria
paper
presentation
presentation.
on AI and algorithmic bias in criminal investigation. Shikha, are you?
I am ready.
Okay. Are you going to be presenting a PPT?
Yes, ma'am. Yes, ma'am.
I'll give you the rights. Shikha, can you unmute yourself?
Ma'am, I am audible.
Excuse me.
Yes.
Next paper presentation I have to give.
I cannot hear you.
Ma'am, next paper presentation I have to give.
You have the next presentation, Ronald.
Yes.
Just give me a moment, I'll check.
Ms. Shikha, can you unmute yourself?
Ma'am, I have done. Ma'am, Himanshi Lakhmani will be presenting, ma'am. Hello.
Okay. Can just
Yes, ma'am.
just mute yourself
Kindly
for a
unmute.
moment.
So Himanshi was asking me that it is her chance to present, or was it somebody else?
Ma'am, it
That
was
was Mrinal,
somebody
right?
else. Yes, ma'am.
Right. So Ms. Mrinal, kindly check the program schedule. The 18th numbered presentation is of Ms. Shikha and Himanshi. We will take their presentation now. I am unable to give you the presentation, right? Himanshi is going to present, right? I cannot see you, and I am unable to give you the rights. Can you just try sharing the PPT for once?
You can unmute yourself, Himanshi.
No, ma'am, I'm not able to share.
I am not getting the option to give you the presenter rights here.
Without the presentation.
Yeah, can you go ahead without PPT, Himanshi?
Okay.
Is that okay?
Just give me a moment.
Okay.
Deepika, I have given you the rights to present.
Okay, ma'am. Thank you.
Thank you for your patience, everyone.
Ma'am, is this visible?
Yes.
Okay. Good afternoon, all. Uh, our topic is from human judgment to machine biasness, the jurisprudential impact of AI in crime investigation. In our research paper, we have came across, firstly, in the introduction, we have done that what is the interface of artificial intelligence with our criminal justice system. As we all know that we are living in the transformative areas and transformative generation, a student is also using a chat GPT. People are using small apps for morphing the images and using the AI in such a frequent way, which has become a thought process for everyone to come on this topic. Artificial intelligence acts as a transformative. It is a transformative technology, but at the same time, it has a dual-edged force in the criminal justice system. As a coin has two faces, same as artificial intelligence too have. First, we needed artificial intelligence to inject in our criminal system due to the urgent need of transformation, because it has solved many majorly two problems, that is massive pendency of cases and deficiency of workforce, because it has interconnected to all the our criminal justice. Second thing, at the same place, is it has become a challenge and unaddressed risk that it is threatening the individual privacy, which has been introduced or talked about in our chapter number 2. And second thing, it has also created that if we are using AI technology, it is analyzing those things through the basis of the past prolonged data which has been provided to the AI or our technology. Because as the crime pattern has is keeping on changing day by day, but the AI information which we are providing to AI is based on the past, the pattern and things which will be brought up, or the results which will be coming out will be on the basis of the past result, the crime patterns and things. But as a judiciary is not static, it's static, so it keeps sorry, it's dynamic, so it keeps on changing, the pattern also keeps on changing, due to which it is creating a challenge for AI too. And our criminal justice is the result which has been brought by AI is accurate or not. If it's not accurate, how can we bring it to in the system? Because if we are bringing something in the system, it has to be authentic towards that. And second thing, it's not codified, as we all know that. But AI, so we'll come in our paper, we have discussed the AI practical application which has been used in justice. That is a predictive policing, that is a app Predpol, which creates a hotspot places where the crimes are very prominent, so that it brings intimation for the police officers and all that to have a look and being cautious for the specific places. Second, it has AI has given us three-dimensional models so that we can analyze the investigation, how the investigation can be clearly possible. And second thing, we have seen our AI in the forensic DNA analysis also, because through that AI has created a data authentication and keeping the DNA results for a longer period of time, and it has brought that the results which AI is giving on the forensic analysis is much more better and efficient than a normal forensic person who is giving the results. Second, forensic DNA analysis has brought through our blockchain technology. It is connecting too many technologies for bringing our result, and through that results, it is also creating a pattern for other DNAs also, that the DNA test which has been done previously patterns are
creating a result for AI to bring a much better result in new other cases also. And as we all know that it is AI is also used in handwritten sampling also and voice sampling also. And in our second topic, our second chapter, we have dealt with the rising tides of AI risk. As in 2013, right now it's very prominent to listen this chat GPT and all that, but the target system was already introduced in 2013 when our Supreme Court and our government came across with our e-committees to form an interoperable criminal justice system which has interconnected our courts, prisoners, forensic labs, our public prosecutors and police, all the this pillars, all our five pillars have kept interconnected through this interoperable criminal justice system, and to bring for one data one entry. If one data will be entered in a place, it will be circulated in everywhere, so that there cannot be a miscommunication or misdatification of anything. And in first, as the slide shows, that in the first phase, initial implementation was what, and then in phase 2, it was a interoperable across all five pillars which has been mentioned by me. Then after that, a specific software, that is Jarvis, was bought by StackQ. It has been a very prominent technology company which have been merged with our government, many governments, state governments and central government. Jarvis was a company which was introduced, which gave this software in 2019, which was a video analytically to monitor and identify violent occurrence in real time using CCTV footage. Then came our PAS, Police Artificial Intelligence, that was also made by Stark Company only for the Punjab Police. Then came our Trinetra, which our paper is dealing with a crime GPT. It is a Trinetra is a crime GPT is a 2.0 version of Trinetra, which has been brought last year in 2024 by the UP government to analyze the comparable features to Paris, actively assisting police in UP. In this, it has given 5 features for that, because it has created a facial recognition, speaker identification, network analysis, and voice recognition in this software, which again, through the AI technology, investigators is possible for them to analyze the facial recognition from the older data which have been provided to artificial intelligence, and it is showing a very remarkable results also. But at the same place, after discussing these all things in our paper, we came across with the problem with a privacy hunch. It was creating a privacy problem because, as in our DPDP Act and IT Act, there are many sections where the assumptions are given to the government on central government to exclude them from data privacy. Means the personal information can be accessible by the government on the exception basis. But at the same place, because this Stark Company and all that are a private sector, which is creating that how are the data provided, creating a problem to privacy. Then through that, in our research paper, we have discussed a Stanford 2025 AI index report, which shows that the AI has created a privacy problem case reported in their country. And then we have discussed lot many things, that in DPDP Act, if we are giving the information to government that we are allowing data protection, data usage, so many hackers which are together in the market to capture this. How are we as a government protecting the data which has been provided to government? Because it is assumed that it can be used at many places. Okay, we can control a private companies or many other companies, but how, if the assumption are be given to government, so the government should protect that. For that protection only, as a slide shows, which we have discussed, privacy versus public safety, for that protection,
government has created this advanced privacy enhancement techniques, which has been discussed, that anonymization. First technique is anonymization, completely erases the personal identification information, making the data non-traceable to the individual. Okay. Then pseudonymization replaces the real identification like name with fake names like A123, making it harder to link the data back to a person while keeping it usable for analysis. Then K anonymity ensures that any single record, there are at least K other record that share the same characteristics, making it impossible to single out an individual within that group. Synthetic data generation uses advanced method like generative adversarial network, that is GAN, to create artificial data that minimizes the statistical property of real data but contains no personal information. These new privacy enhanced technology, that is PET, have been introduced in many countries like USA and all that, which I would like to discuss also that in California has enacted Consumer Privacy Act also. In my conclusion, I would only say that we should also have a Consumer Privacy Act. If our government is allowed or assumpted in using these all technology to have a good impactful technological use, so I would say that it should have a Privacy Act also, that it could be a better one. Thank you. Thank you, ma'am. Should I leave? Thank you.
Thank you, Shikha. Thank you for your presentation. Next, do we have Miss Purva? She did say that
Yes, yes.
she joined late. And okay,
Hello.
Purva. So, do you have a PPT with you?
Yes, I have my PPT.
Okay, I'll give you the presenter rights.
Yeah.
Miss Anjali, please be ready after this.
Yes, ma'am.
All the other participants, kindly note that if there is anybody left who is yet to give their presentation, kindly give your names in the chat box so that we can make a note of the same. Miss Purva, I have given you the presenter rights. You can share the PPT now.
Is my screen visible?
No,
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 it's not
Purva, it's
visible.
not.
Now?
Not visible.
Okay, let me try it. Because I have selected share screen. Is it visible, ma'am?
No, Purva, it is still not visible.
Ma'am, don't know what's
I
wrong.
suggest you continue without the PPT if that is okay with you.
Okay, ma'am, let me try it once. Is my screen visible now?
Yes, now it is visible.
Okay. It is the topic of my presentation is, firstly I would like to introduce myself. My name is Purva Gupta. I am a practicing lawyer at Rajasthan High Court, and I'm a research scholar from a part-time research scholar from Manipal University, Jaipur. The topic of my presentation is Indian electoral process and the criminal justice system. As we all know that electoral process is the heart and soul of the Indian democratic setup, and which calls for the principle of free and fair election, because unless and until the elections are considered to be free, fair and healthy electoral process, the democratic system of government cannot exist in India, because it is the government of the people, for the people and by the people. Every person, every citizen must have their equal rights, duties. They must enjoy all their forms of freedom, equality, and for that, we need a free and fair election. but the electoral process has been seen to be facing various obstacles due to the criminalization of politics, and which calls for the uh, some effect over the criminal justice system as well. It is a form of one form of corruption which has affected and infected the healthy electoral process. The causes of criminalization of politics are such as, first one is the politico criminal nexus. One is the politicians, they have strong ties, affiliations, or associations with the criminals or the gang leaders because they need more votes and they need to have a better approach with the localites. So, for that purpose, they maintain their ties with such people. Or some, on the other hand, many various the in areas or the some states, only the criminals they get into the politics, they secure the tickets from various political parties, whether the regional parties or the national parties, and then they contest for elections. So this is one reason. Second is the high cost of election. The high cost of election is that the campaigning in nowadays there it calls for high cost of expenditure in terms of campaigning, because every candidate uh, tries to fetch a good vote bank, and for that they yield to take various type of things like distribution of money, giving influences or various incentives at that personal levels. So that is one cause. Then it results in lack of governance. Lack of governance is every election that takes place under the observance of the local body and the local administration. So at that level, the officers, whether at the administrative rank or the police department or prosecution, they unwantedly they have to support the ruling parties candidates or the coming candidates, because they are under various pressures. For the example, their transfers, their promotions, or many other departmental things. Then slow judicial process. So slow judicial process takes place because various times the candidates who have a criminal background or who are already ongoing with the less pendants, so they the police or the prosecution department, they slow down the trial against those criminals, because there is a use of muscle power. Everyone is threatened about their personal liberty, their security. This is one reason, and it results in at the end in the narrowing of the self interest. The effect of criminal justice system is that against the principle of free and fair election, the free and fair election principle remains hampered due to the such type of use of muscle power, money power, and the candidates as well as various voters, they are not free to choose their own candidates during the electoral process because they are under various type of pressures. It leads to against a hampered good governance, and the integrity of public servants also remains suppressed due to such criminalization of politics, the intent of corruption in this. The social harmony also remains suppressed because the prioritization is given to the various forms of caste and religion based vote banks. Then we talk about constitutional and legal provisions to reduce the criminalization of politics. The Representation of People Act 1951 talks about the disqualification under Section 8, that the individuals convicted of heinous crimes or sentenced for 2 or more years, they face disqualification. Section 11 gives the EC the power to remove or reduce the period of disqualification. This power was utilized in the September 2019 to reduce the disqualification. After that, there came the 138th Constitutional Amendment Bill, which seeks to amend the Article 75 and 164. It proposes that a minister arrested and detained for 30 consecutive days for an alleged offense punishable with imprisonment of at least 5 years shall be removed from the office. After that, talking about various judicial pronouncement, if we talk about the role of Supreme Court or the pivotal role of Supreme Court in curing the criminalization of politics, then there are various judgments. First one is the Public Interest Foundation versus Union of India. In this, it was directed that the political parties, they must publish online pending criminal cases of their candidates on various social media platforms. Second is the Lily Thomas versus Union of India, in which it was held that immediate disqualification for sitting legislator and convicted and imprisonment for 2 or more years. Third is the Union of India versus Association of Democratic Reforms, or ADR. The Election Commission of India must take the affidavits from the candidates having past criminal records and recording the quantum of punishment. It was also had in the ADR report of 2024 that there has been an increase in the 55% of those MPs having a criminal background. See on free and fair election. The notion of free and fair election is a part of the basic structure of the Indian Constitution. And in the case of Keshwanand Bharti versus State of Kerala, it was held that the entire scheme of Constitution is such that it ensures the sovereignty, integrity of the country, as well as a republic and democratic way of life. The People's Union for Civil Liberties, and in this case, it was held that free and fair election is a basic structure of Constitution and necessarily includes within the ambit of the Constitution. It ensures the right of equality under Article 14 and which shall not be violated at any cost. Then we talk about the ICT initiatives. The ICT initiatives refers to the information and communication technology initiatives, that is the use of technology in the 75th year of the uh, Azad Bharat. We are using all sort of information technology uh, initiatives to cure the criminalization, the use of money and muscle power in politics. So various forms are electoral registration officer. One is that this portal, it is a web-based portal which is used for registering the voters, their updated information with regard to their correct name, address, and everything. Then election monitoring dashboard. This dashboard provides with the details of the election activities such as polling and counting. Third is the digitalization of the electoral rolls. And we all are aware with the electronic voting machines, EVMs. The EVMs, they provide with a very good alternative of the ballot paper. But nowadays, we have also seen in various states in the past election process under MP and Rajasthan that the EVMs have also been stolen. So that is also a part of the criminalization of politics, because the use of muscle and the money power has hampered the EVM system as well. The voter verification paper audit trail, VVPAT, is also being used, and the political finance management system. This is one system that has been given to cure and record the amount of fund that has been expended upon the electoral process of every state and the national level. Then we have a social media monitoring system that has been given to provide with the various details of the candidates during the electoral process and during the implementation of MCC, the Model Code of Conduct. After that, lastly, I would like to talk about the suggested measure. The enhanced penalties should be there for the false affidavit that has been filed by the candidates during the filing of their forms, and the dedicated election benches should be there at the high courts who are only exclusively meant to deal with the cases of disqualifications. There must be a review of Section 11, that is, it talks about that only 6 years bar is given to a candidate who has been imprisonment for 2 years. Why not for the entire life? Once a criminal is always a criminal. Then financial and transparency reforms. Political parties should be brought under the role of RTI. There should be no application of Section 8 and no confidentiality with regard to the transparency of the political parties reform. Various committees such as the Dinesh Goswami Indrajit Committee on the Electoral Reforms have recommended for state funding of elections that will cure the use of black money to a greater extent. Regulating the affairs of political parties is essential for cleaner electoral process. Therefore, it is imperative to strengthen the election commission, and voters also need to be vigilant with regard to the misuse of money, gifts, and other inducements. Given the reluctance by the political parties to cure the criminalization of politics and its growing detrimental effects on Indian democracy, the Indian courts must now seriously consider banning the people accused with serious criminal charges from contesting the elections. Thank you.
Thank you for your crisp presentations. I now invite Ms. Anjali to share her paper with us. Ms. Anjali, are you ready?
Yes, ma'am. Am I audible?
Are you going to be sharing a PPT?
No, ma'am, no.
Okay, kindly start.
Okay. Good evening, everyone. This is Anjali. My topic is on democracy behind bars. And by democracy behind bars, I mean voting rights of prisoners. So, as we know, India is a welfare state. and India is one of the oldest democratic countries in the world. So, so for a democratic country, right to vote is the fundamental aspect, and also voting right is a key element of a democratic system, where it involves civic responsibility. Not only we can say it's not only a fundamental right, but also a vital duty of every citizen. Now, when we come talking about this, uh, if we talk, talk about why voting right of prisoners is important, or why it's important in Indian context. See, the inmate voting rights, it intricates various questions regarding fairness, then retribution, reintegration, and democratic principles. Before coming to Indian context, I'd also like to talk about international standards regarding the voting rights. There are this UDHR, Universal Declaration on Human Rights. Then we have ICCPR. Then also ICERD, International Convention on the Elimination of All Forms of Racial Discrimination. So if we talk about UDHR, we all know there are 30 articles in UDHR. And related to voting rights in UDHR, it's given Article 21. Yes, Article 21 of UDHR talks about that everyone has to take part in the national governance. Also, UDHR is widely recognized as part of the customary international law, which gives it a binding force in global legal discussion. Article 21 of the UDHR, it highlights the importance of voting and active participation in a democracy as basic human rights. Also, while the issue of allowing prisoners to vote remains debated, it is essential to consider principles of equality, justice, and rehabilitation when forming principles on prisoners' voting rights are considered. Then ICCPR, International Covenant on Civil and Political Rights. This also talks about human right, where if we quote the preamble of the ICCPR, it says that in accordance with the principles proclaimed in the Charter of the United Nations, recognition of the inherent dignity and of equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. So the ICCPR, it enunciates that the rights and freedoms under the treaty are generally guaranteed to all individuals who are present in the territory of the state and are subject to its jurisdiction. Okay, if we talk about Indian
Ms.
context.
Anjali, kindly conclude in the next 2 minutes.
Okay. If we talk about Indian context, then Article 326 of this Indian Constitution, and the statute Representation of People's Act. We all know Article 326 and Representation of People's Act. This talks about the prisoners' prisoners' voting rights in India. So the Representation of People's Act, this bars prisoners to cast vote. And here under-trial prisoners, along with the prisoners who are convicted, under-trial prisoners are also barred from exercising the right to vote in all local as well as national elections. So denying voting rights to the prisoners, it raises various concerns like about fairness and inclusivity to the electoral process. There are various judicial pronouncements, Ankul Chandra Pradhan versus Union of India, then there was PUCL versus Union of India, then one was S. Radhakrishnan versus others, where the validity of Section 62 Clause 5 of Representation People's Act was upheld, the validity of it. So if I have to suggest regarding the prisoners' voting right, if I have to analyze and suggest, according to me, denying prisoners the right to vote, it appeals to the concept of retributive justice. Also, taking away the civic right as a form of punishment may discourage the future criminal behavior. So there can be some suggestions regarding this. For example, The prisoner should be classified on the basis of the offense committed, such as under trials versus convicted offenders, or non-serious offense versus serious offense, non-violent petty crimes. They should be allowed to vote like that, or there can be a transparent and uniform legal criteria for disenfranchisement. Uh, since the 62 clause 5 of RPA imposes a blanket ban on prisoners voting, so I think it's a violative of right to equality. And this raises a significant questions about the role of punishment and the right of citizens. The principle of universal suffrage is a cornerstone of democratic societies, and excluding prisoners from these rights challenges the inclusivity and also the fairness of the electoral process. I think I have done.
Okay, Ms. Anjali, thank you so much for your presentation.
Thank you.
I extend my gratitude to all our presenters for sharing such well-researched and thought-provoking papers. That was the last presentation of this seminar, and each presentation today has contributed significantly to our understanding of procedural criminal law in India and beyond. May I now request our respected chairperson, Dr. Preeti Rana ma'am, to kindly share her comments and reflections on the papers presented in this session. Ma'am, please.
Very good evening to Dr. Nityanand, because earlier I didn't get a chance to convey my regards to you. And once again, a heartfelt gratitude to the university and the coordinating members for organizing such a wonderful seminar on such a pertinent topic of criminal law, justice and reforms, as I said. But I would like to give a huge round of applause to all the presenters here, because as over the last 2.5 hours, we covered all the facets related to the topic, wherein we talked about the stateless people, we talked about doctrine of proportionality, we talked about the concept of arrest vis-a-vis BNSS and electoral reforms. And a few of the papers were very well researched, particularly I'm forgetting the name of the presenter, but wherein we talked about the case studies with respect to the concept of under trial prisoners, and also the very first presenter who talked about the stateless concept. So yes, it was a very well deliberated presentation by all the presenters, and I would like to congratulate each one of you over here. So once again, thank you to all the organizers for giving this opportunity to hear all these presentations here. Thank you.
Thank you so much, ma'am, for your time, for your valuable observations, and for guiding this session with your thoughtful insights. May I now request our co-chairperson, Mr. Adarsh Pandey, to propose the vote of thanks for the technical session 2 of this seminar.
Good afternoon, everyone. I'm audible.
Yes, sir.
Okay. So I'm here to present vote of thanks to respected ma'am. It is my honor and privilege to extend a heartfelt vote of thanks to Dr. Preeti Rana, Assistant Professor, Faculty of Law, University of Delhi, for gracing us as the session chair for this technical session. Ma'am, your insightful observations, thoughtful guidance, and valuable comments have truly enriched today's session. On behalf of GH Raisoni Skilltech University, I sincerely thank you for taking out time from your busy schedule to be with us and for making this session both engaging and intellectually stimulating. I also extend my gratitude to all the paper presenters, participants, and organizers who contributed to the success on this session. Thank you, ma'am, once again for your presence and encouragement. Thank you.
Thank you so much, sir, for your words. Next, I would like to request Dr. Mukti Jaiswal, Assistant Professor, Allahabad Degree College, Prayagraj, to present a valedictory speech.
Thank you, ma'am. Thank you so much for giving this opportunity to me. At the end of this entire event, I had got this privilege to convey the valedictory speech at the end of this event. So it is indeed an honor and a privilege to deliver the valedictory address at the conclusion of this intellectually enriching national seminar on criminal law and justice reform. I would like to congratulate the organizers of the seminar, the School of Law, G.H. Raisoni, Skill Tech University, Nagpur, in collaboration with our own Faculty of Law, Allahabad Degree College, a constituent PG College of University of Allahabad, Prayagraj. This partnership has truly exemplified the spirit of academic exchange and collaborative learning. First of all, I would like to extend my heartfelt gratitude to the chief patrons, Honorable Shri Sunil Raisoni, Chairman, Raisoni Education Group, and Honorable Professor Piyush Ranjan Agrawal, sir, Chairperson, ADC, Allahabad Degree College, Prayagraj, to the patrons, Honorable Vivek Kapoor, sir, Vice Chancellor, G.H. Raisoni, Skill Tech University, Nagpur, Professor Dr. Atul Kumar Singh, Principal, Allahabad Degree College, Prayagraj, Professor Dr. Nityanand Pandey, sir, Dean, School of Law, G.H. Raisoni, Skill Tech University, Nagpur, Professor Dr. R.S. Bisaria, sir, former Head of the Department, Faculty of Law, Allahabad Degree College, Prayagraj, Dr. Neelam Singh, ma'am, Head of the Department, Faculty of Law, Allahabad Degree College, Prayagraj, and Dr. Farhat Khan, ma'am, Dean, School of Law, G.H. Raisoni University, Sai Kheda, for their continuous guidance and directions in organizing the entire team for this national seminar. Further, I would like to brief the entire event. This seminar is started with the inaugural ceremony graced by the presence of our chief guest, Honorable Shri Bhushan Prakash Shri Shirsagar Sir, Registrar Administration, High Court of Bombay, Nagpur Bench, inspired us with his thought-provoking insights into the judicial dimensions of criminal justice reforms. His words have reminded us that true justice is not about punishment, but also about fairness, compassion, and societal transformations. Then the seminar was further proceeded with the two thought-provoking sessions. I wish to place on record my appreciation for the chairpersons and co-chairpersons of both the sessions, Dr. Santosh Kumar Sharma sir and Dr. Kiran Singh ma'am, Dr. Preeti Rana ma'am, and Mr. Dhish, and Mr. Adarsh Pandey sir, who has whose expert moderation enriched the sessions. A special mention to our moderators, Mr. Dhish Gushia and Ms. Abhiruchi ma'am, for seamlessly conducting the proceedings with professionalism and grace. Over the course of today's deliberations, we have witnessed insightful discussions on some of the most pressuring issues in criminal jurisprudence, from technological advancement in investigation, arrest, and evidence to victim-centric and witness protection reforms, plea bargaining, and the assessment of the new criminal laws. The distinguished speakers and paper presenters have sharp, deep perspectives that have challenged our understanding, broadened our vision, and strengthened our collective resolve to pursue justice through reforms. Further, on behalf of the organizing On behalf of the organizing institution, I extend our gratitude to the participants, delegates, and the attendees, along with the dignitaries, both offline and online, for their enthusiastic engagement. It is our curiosity and it is your curiosity and commitment that makes such academic gatherings truly meaningful. I like to congratulate and appreciate the conveners and co-conveners of the seminar, Dr. Raman Bharadwaj, Dr. Harish Kumar Tiwari, and Ms. Nidhi Kastwar of both the institutes for their efforts which they had made from last few months for the conduct of this event. A special mention to the faculties, technical and non-technical staff, administrative and subordinate staff for their contributions behind the scene for making this event a grand success. Once again, I'd like to thank the organizing committee for their tireless efforts, the distinguished guests and for their presence, and everyone who contributed to the success of this seminar. At the end, I just like to say a single thing, that let this not be an end, but a new beginning, a reaffirmation of a shared mission to make justice more accessible, human, and technologically empowered. Thank you all, and I wish everyone continued success in the academic and professional journey. Thank you so much.
Thank you, Dr. Mukti Jaiswal ma'am, for your enriching valedictory speech that perfectly encapsulates the essence of today's seminar. With this, we officially conclude today's national seminar on criminal law and justice reforms. And on behalf of the organizing team, I extend our sincere gratitude to the dignitaries, chairpersons, co-chairpersons, presenters, participants, faculty members, everyone for their valuable contributions and presence. Thank you all for making this academic event a success. Thank you so much. Have a wonderful evening ahead.